Invite and video, selecting meeting out.
Aha.
You uncheck blur my background video, and then let's shift the mic. Make sure. Sometimes it lags a little bit.
Yeah, that one. I knew I was debating sweater and then.
You're good.
We're good?
Yes.
I should know.
Okay. And then does it need to be, oh, oops.
I saw both of those items for the meeting.
I don't know, I don't.
For the microphone?
Yep, so the microphone is owl, and then you're also gonna hear sound from that.
Should it be, wait.
Yeah, it's also a speaker.
Hold on, I just want to double check one thing. Should it be on this one?
Oh, yes, yes.
No, you're good. Okay, so I think it's like, so then I'll turn it off for now until they start.
Good, because I had.
Is it hard?
Conversation with everyone.
You have to Zoom.
COVID. Yeah. That was- I remember they coming back from prison. And I said, broken record, you want to see me in chambers. And this guy should be on probation. You know, I said, I don't know. If the guys have no dangerous records, they ask for probation. And it's a seal. So if the guy then goes and kills somebody down the road, he'll take responsibility. I don't see the joke. And
Aloha, everyone. Good morning. Those of you who are here in the Capitol and those of you who are online, good morning to all of you. And thank you for being here for our November 2nd meeting of the Hawaii HCR 23 Task Force. So it's glad to see everyone here. I'd like to just begin with a few things before we get into the meat of the things. I'm thinking of starting off with just an olelo noheau, something from our ancestors, put us in the right frame of mind with a saying, "Aohe hana nui ke alu ia, aohe hana nui ke alu ia," is no task is too big when done together by all. So, we have a big task together, and I definitely gonna need, or the commission is definitely gonna need everybody here to make the best recommendations we can by a year time. So thank you all for being here. We continue to move forward. We have a good program for us today, or process to help our thinking as we move through. I want to do a real quick roll call to see who we got here, both present and online. So if you hear your name, just say here, and then we'll move forward. Real quick before we begin, so we can check our tech. Keldon, can you give us a mic check so I know you're online?
Hello, testing 1, 2.
Okay, all right, thank you. Thank you, Hilo. Yeah, so right on, we can hear you folks. Kevin Souza. Here. Adrian Daka.
He's gonna go away. He's
Okay.
in court.
Brenda Bauer-Smith. Thomas Johnson, excuse me. Lindsay Hulu. Fred.
Here.
Fred Hewen, sorry.
Yeah.
Henry King.
Yeah.
Mark Helsham.
Here.
Glenn Wakai. Steve Alm.
Yeah.
Keola Sui. Andrew Martin.
Here.
Keldon Rachin. Pamela.
Here.
Thank you, Pamela. Miles. Here. Brandon Segal.
Good morning.
Thank you, Brendan. Andrew Kennedy. Craig DeCosta.
He's
on mute. Yeah.
Oh, that was
So-
me. Did I say here to the wrong person? I'm here.
No, we're good. Thank you, Craig. Sonoy Kaihui
Here,
and Martha Ross.
here.
Okay. They're doing it.
Andrew Kennedy's in the federal court for this trial.
Okay. All right, thank you, everybody. That's about a little over half of who's on our roster. So I appreciate that. Just want to go over really good that, we operate in this room and with the discussions that we have with a lot of aloha. Don't have to remind you folks here, it's statute that we treat each other with a lot of aloha. and that our meetings should be positive and solution-based, and we treat each other with kindness. We hold each other accountable. That this is a safe space to share, and discuss the issues at hand and the mandate that we are tasked with. Be fully present at the meetings, be prepared. Hopefully, if we haven't been doing the best we can and giving you information to prepare you, let us know. We want us to be prompt so we can start on time. And if someone is coming in your stead, let us know. Okay. So just a few little rules of engagement so we can continue to have solution focus and positive movement in our meetings. This being our second one. I believe, last meeting, the first meeting we had, and thank you all for being here. We really did a lot of discussion or just touched a bit on what other states are doing in regards to minimum sentencing. Today, we're going to take a little closer look at our second mandate and our first mandate, which is examine and make recommendations regarding existing procedures of the Hawaii Paroling Authority, setting the minimum terms of imprisonment to increase efficiency of the procedures. So we're just going to touch on that. So really looking at these first several meetings as just being providing enough information to try to put us all on the same page from the different perspectives that you represent, and understanding we're trying to make systemic reform or systemic change if need be. So I really appreciate the State Council of Governments being here and assisting us in that and guiding us, navigating us in the discussion. Carl, who's online today, Jennifer, and of course, Jeffrey, who's here with us, leading that charge. So with no further ado, we're ready to get into the discussion. Good morning, Carl. How are you?
I'm good. Good to see you all. I'm sorry I'm not there with you.
Well, it's winter in Hawaii. You might not like it.
Yeah, I'm sure it's horrible.
Yeah.
Well, it's
You
fine.
wanna?
We're here in Austin.
I think we're ready for you to go ahead and take it. Okay, sorry.
No problem. I'm going to go ahead and share my screen. Let me know if this works all right. Let's see.
Are you folks okay? Little louder on the volume.
Maybe that's screen.
How does that look? Can you see it?
I think I'm gonna. I don't want to block anybody. Me too.
You're good, Carl.
Okay. Thank you all. Nice job setting this up, Mr. Chairman. I really appreciate it. I'm going to launch right in. And exactly as you said, the idea here is to provoke some more conversation amongst the group. And to do that, my approach in this presentation is for me to kind of take a deep dive into the statutes that govern all the pieces of this puzzle. And so what I'm kind of doing with you is sharing with you my own mental process. Whenever I get involved in working in a new state like Hawaii, I spend a lot of time literally kind of going through the statutes and the Code of Criminal Procedure, the Penal Code, the law that governs the corrections agency and the parole system, those kind of salient parts of the statutes. And so in this presentation, I'm kind of pulling that up and showing it to you all so that, again, to share that sort of foundational understanding of what's in the law about what's supposed to happen and how it works. But in order to get you all to say more about what really happens and what your role really is like, et cetera. So I want you to feel free to jump in. Mark, you're there in the room. You let me know if I should stop or let people jump up or do whatever. I'm happy to be interrupted. This is going to be kind of a long slog for me, so I'll be tired if I'm not interrupted. So this first slide, just to remind you all that we're privileged to be getting to do this work with you through the generous funding of the Bureau of Justice Assistance. And as you said, Mark, today we're focused on the first piece of the 4-part mandate in HCR 23, which is really understanding how it works now. As you said, the last time we talked about 11 other states and how they sort of structure their sentencing process and set minimums and maximums in many cases, to kind of get an idea of the array of possibilities that United States engage in. But today we want to really focus on how it works in Hawaii these days by sort of marching through the criminal justice process and looking at the statutes along the way. So the process begins when a crime is committed and a victim has been created. Essentially, someone has been victimized, and so I want to say a little bit about the rights of victims right off the bat, and we'll get into victim rights a little bit more as we the specific victim issues that come up, especially in the HPA process. But from the outset, just want to acknowledge that the legislature, I think many years ago, I think this is from 1988. You've had this chapter 801D in your statutes that sets out a series of victim rights, and in particular 801D4, which is the basic Bill of Rights for victims and witnesses. So I'm going to jump to that, and instead of giving you a lot of statutory language, I tried to boil it down into the really major concepts that are listed in that Bill of Rights, and it's mostly about notification, information, and notification. And I know that some of you all in the room have worked on your automated victim information notification system, the SAVIN system that you all have up and running, and that serves some of the purposes of this regimen of notifications that need to happen. And I know that's been a collaborative effort with your Department of Public Safety and so forth. I'm going to pause there and see if that triggers any comments from anyone.
Actually, it's SAVIN system. So I know I sent you a text. So it says AVIN system. So it's the SAVIN system. And I brought some brochures. And I think in relationship to what we're looking at is the SAVIN system within the Department of Public Safety and the Paroling Authority is a standalone system. It's a system where people can anonymously go into the system to find out information. It's a system that the judiciary declined to participate in, so that if there's a change made, the notification that comes through this system will be a significant issue, because that information does not come to victims who we don't know who they are, because it's an anonymous system. So all the people that are signed up right now are not identifiable. So if all the population of people that need to get notification about a minimum hearing are now being handled to the judiciary, it's now an organization who declined to enter information and be a part of the system. And I know Tommy is actually the one, and the Paroling Authority, who do the most work on it. But I know when they discuss this issue with the judiciary, it would take about 3 to 7 seconds for the entry of information into the system to go ahead and do this. But it was not something that the judiciary was prepared to sign on with. This system is a system used by the federal government to notify victims, and also I think every other state has an automated notification system. So I think that's an important fact for making a determination about what works for victims. So this is working for victims, this anonymous system. It's automated. There's a governance committee created by statute. Some of the people were in the room were here yesterday. There's a governance committee made up of victim advocates and policymakers whose mission is to make sure this is a victim-centered system. So what happens is when issues come before that committee, we're able to resolve them very quickly because of the working relationship we have with the Paroling Authority and the Department of Public Safety. I don't see an equivalent structure where the governance committee would be part of telling the judiciary how they would respond if it wasn't working for victims, or that would have to be created separately in order to not hurt victims in this part of their right to notification. And notification is a gateway right. So if victims don't get notified that they have a right to be heard, then they can't be heard. If they don't have a right, if they aren't notified that somebody escaped, then they don't have the ability to protect themselves. So all these other rights really flow from the basic right of notification.
How long ago was that opting out by the judiciary?
I think that, so in the Savin system was initiated in two parts. There was originally a federal grant, and then it was made permanent with state funding in 2012, which was part of the Justice Reinvestment Initiative set of bills was this system. So I think like in 2008 is when Tommy, as part of the Department of Public Safety, implemented the system. I think it was about that time that he went to the judiciary and to talk to them about becoming part of the system. And also the police cell block have also been approached as well to become a part of the system. And that also is something that needs to happen and hasn't happened. So.
Judge Chuzzo, would it be okay if I go? Are you familiar with it?
I'm not, I'm learning about it. Now, I was just gonna ask, what were some of the reasons back then that the judiciary gave for not wanting to participate?
I wish Tommy was here because he's the one who did the work on it.
I can follow up directly.
Yeah,
Not a problem.
So can we?
So they don't get notified of any court, like any upcoming
Not through the
hearings?
automated system. I think it's like a focus of different parts of the system, the focus we perceive of the, I think the victim community in many ways, perceives about the parole board is that, an offender has been convicted. And so when you're at the court, it's the, perception of fairness to all parties. And so when somebody appears in front of the paroling authority, what they're doing, somebody's been convicted, and so the focus is a different focus too. And so I think that it makes sense in a lot of different ways. There's a different function that the judiciary serves in many ways. And that I think this conversation is as much about that, is the focus of each of those organizations. And for us, that focus profoundly impacts what has happened in the real world for victims, that the Savin system was created because these two organizations, the Paroling Authority and the Department of Public Safety, wanted to make sure that this was available to victims. And so the fact it didn't happen with other organizations, I think is a reflection of some of the concerns that we have about what's going to happen for victims if things move over to another organization.
Very helpful. Thanks, Pamela.
So this is my burning question, Emma. We've known each other a long time, so I know you've been working in public safety and doing the movement in terms of the victims. Are we saying the judiciary has their own system in contacting, or is it still trying to? Do you get contact with the individual and the victim at the time of arrest in jail?
No. So there's different parts of that. I think there's more than that. It's more complex than that. So maybe we can pull that together and look at the arc of when where victims touch each point of the system, because when the prosecutor's office really is the main focus. The victim witness programs are the people who deliver those types of services. And then Tommy Johnson, the Paroling Authority, post-conviction victim services are now a big part of the efforts of corrections and the Paroling Authority. We had a VOCA grant we worked with Fred on that delivered post-conviction victim services. The Department of Public Safety's Victim Service Office is now co-located within our office. So the article about restitution that I think will come up somewhere is an article that we wrote with the Council of State Governments, because the restitution project that we have at the Paroling Authority and Public Safety is a national model. And so it shows that the narrative that offenders can't pay really isn't a correct narrative. So there's a really deep commitment, I think, and surprising, I think, when people call us from places on the mainland to ask about how we were able to, especially on restitution, make these issues work. It's because the surprise to us in many ways too was the partnership that we have with organizations that are really traditionally offender centered. That has been really important in making that work for them.
Oh, thank you, Beverly. There's a lot in my mind right now, but Carl, go ahead and let's see if more can be pulled out of the discussion here with your presentation.
You bet. So flipping over to the side of the accused, you have some constitutional rights spelled out in your Hawaii state constitution. In particular, section 14, rights of accused, is a long paragraph that describes the same kind of rights that you see in the Bill of Rights in our United States Constitution. Right to a jury, right to confrontation, right to be able to subpoena witnesses, to notice of what the charges are, all those sorts of things that are sort of, key due process elements. Those are mostly spelled out in section 14. And then there's, I've listed the executive powers. It's not really a right of the accused, but I think it's always interesting to know what's going on with clemency in a state system. And it's usually clemency is lodged with the executive, with the governor, typically. Sometimes there's, some states have a little different approach, and it may be like a committee of the governor and the lieutenant governor. But in Hawaii, it's the governor. And I think the paroling authority has a role in making recommendations around clemency to the governor. But that's an important piece of your system. Usually not a big volume operation, but an important safeguard in justice systems. And then your statutes, alongside the statutes around victim and witness rights in that same area of law, the 801 area is kind of a repeat of what's in the Constitution in terms of some specific rights around indictments, witnesses, and so forth. And then we're
Hold on, Carl.
sure.
Well, let me elaborate a little bit on what Carl's talking about.
Yeah.
So the parole board, by statute, the parole board and public safety, parole board, well, the paroling authority will receive all party clemency applications, do an investigation, review by the parole board with a recommendation that goes to public safety director, that goes to the AGs and the governor's office. All right, so that's by statute. Now, by constitution, the governor has the executive authority to do whatever the heck he wants or she wants without any statute prohibiting it. So there's two levels of granting clemency and or pardon.
Thanks, Fred.
Go ahead, Carl.
So we're about to segue into the judicial process itself, and I wanted to lead into that with flagging some very specific mentions of victims in the judicial process, in particular in the statutes that govern PSIs, pre-sentence investigations. So you've got these, and this set of statutes is going to come up again in a little bit, but here I just wanted to lift up the notion that, as Pamela just said, the prosecuting attorney is involved in informing the victim of what's going to happen with the court process. PSI court staff are required to give victim notice about the Crime Victim Compensation Act, and victims have this statutory right, this opportunity to be heard with respect to sentence in 706-604. And that's regardless of the PSI, whether a PSI was waived or not. That right of a victim is in statute and is supposed to be carried out. And I'm going to hesitate there and see if there's any commentary.
Digest votes.
You want to say that again?
Yeah.
Carl, just go there.
That over again.
What?
Can you repeat what you just said within the past minute?
Yeah, I was just focusing on the last section of statute on this page, 706-604. In all circuit court cases, regardless of whether a PSI has been prepared, the court shall afford a fair opportunity to the victim to be heard on the issue of the defendants, on the issue of sentencing.
From the judicial point of view, yeah.
Okay, so the PSI is one thing for sentencing, but under the statute, and there's sometimes seemingly conflicting parts to the statute, is that the judge may waive it under certain conditions, that defense counsel and prosecutor could stipulate and judge concur to waive the PSI. So in essence, public safety will get no PSI to do their RAD assessments, let alone come into play for minimum hearing. So we have seen a lot of cases, especially from neighbor islands, where no PSI is generated, and public safety and paroling authority have very limited information about the background, social history, drug use, other than self-reporting when the inmate is admitted into the facility. So, that's a conversation that we'd like to have further. And about 4 or 5 years ago, I met with Third Circuit at their quarterly meeting, judges' quarterly meeting, and it helped a little bit. And we're kind of reverting back, but everybody's talking about manpower and shortage and the ability to do a comprehensive report. The other option was to look at the probation officer's report, which is also confidential, but without a PSI, public safety and HBA as well as a community, to me, there's a shortfall and a disservice. Because without proper treatment within the facility and back into the community and transition, you put the community at risk for increased recidivism.
That said, it's rare in Honolulu not to have a PSI.
Oh, it's happening.
Or it does happen, but not.
Yeah, so under 701-601 subsection 4, there are only 3 for felony cases, right? There's only 3 reasons why a PSI can be waived by the judge. Number 1, it's a misdemeanor case, so it's not a felony. Number 2 is if there's a Rule 11 agreement which specifies the sentence. And number 3 is, I'm sorry, 4 reasons. Number 3 is if the defendant is going to be sentenced to prison. And number 4 is if the prosecution and the defense agree that the PSI will be waived. I will tell you, and I handle as many felony cases as anybody else, it's very, very rare. Unless like it starts off as a felony, defendant pleads out to a misdemeanor, then sometimes I'll sentence right away. In which case they don't touch parole. But if someone's gonna be sentenced on a felony, it's very rare that I will allow the pre-sentence report to be waived. Now, on the neighbor islands, you hit the nail on the head. It's a function of finance. They don't have the same cadre, if you will. It's a subsection of the adult client services branch, the probation office. They're the ones that prepare all the pre-sentence reports, right? And so they don't have that similar setup on the neighbor islands for a host of reasons, primarily financial. And so I think you're right, on the neighbor islands, these deals, when deals get worked out, part of the agreement is they'll waive the PSI and they'll be sentenced immediately. The most important part of the PSI, I think, for your purposes is the police report, the underlying facts and circumstances of the case, but also attached to the pre-sentence report is the victim impact statement, right? Which is very meaningful to me. I always make sure that I read victim impact statement, any letters from victims, as well as any letters from the defense side that are oftentimes attached or appended to the pre-sentence report. All of that information is helpful, and that's why I don't generally proceed without a PSI in felony cases.
Well, and partly it's important that judges are educated to exactly what Fred's saying, because if they don't get the PSI later, they are really hurting for that. And once in a while, if there's been a PSI done in the last year, they'll do a abbreviated report with an update or something. But even in cases where, unless there's other exceptions. They really should have a PSI in every felony case.
Well, the statute requires it other than in, like I said, with very specific exceptions.
But there's, I can't think of the statute right off the top of my head, but it says that public safety shall receive a social security PSI upon upon admission by the judiciary.
I think it's 706-669. It's a part of 706-669 that says that you guys have a right in making your minimum determination to receive a PSI.
Yeah,
That's right.
So, real quick. So right now, it's safe to say that there is some who are convicted that sit in front of the parole board at the time of their minimum sentencing.
Right.
That may not have a PSI.
mhm.
Is it mostly coming out of the third circuit?
Well, we have all circuits, but one circuit rated more than others, and, you know, we've had discussions, Sheldon, Alma, and, we tried to look for even just if a PSI was generated within the last 3 or 4 years, just an update to the PSI. You don't have to go up full.
I do agree with Stephen. In this, the first circuit, pretty much everyone gets a PSI. The only time, at least from the defense side, if I'm Ryan, we generally follow what the court's inclination is. The court will reach out and say, well, counsel, do you really want a PSI? So you're not gonna insist on it. The court's giving us a signal they want to sentence the person. It's primarily, as Susan said, primarily the misdemeanors that have been sort of
Yeah.
court.
Misdemeanors, we're not too concerned about, when we're looking at
Yeah.
long-term bed space and treatment. You know,
I practice in all the environments, and consistently, like I want to for Elo. When I'm on the Big Island, I'm often experience the court wanting to inquire, why do you need to have this in writing? Can't we just agree to this, you know, in chambers and what was moved forward? We get a lot of informal resolutions, we're on appeal, we're going through the procedures and we see what happened, and we see nothing that's reflected in the minutes. Call the attorney to find out that, again, it's on Big Island, everything's done because of Aloha, defense counsel, the prosecutor's office, and the court. You know, Maui, Andrew, you guys always insist upon PSI.
Yeah, and but it's not that there aren't instances, I know, when PSIs aren't requested. It's usually, I think, an issue of convenience when the parties have agreed to a prison sentence. As Judge mentioned, but the interesting thing that Fred points out is, of course, when you've agreed to a prison sentence, we're just thinking about the judge, the court knows, everyone knows where this is going, but then what happens is HPA doesn't have the information that they need. I think my deputies are generally very good about, even in instances where a PSI, we've agreed to waive it, that I've been in court when they've asked the court for just a little bit of time to notify the victim to make sure that they have their opportunity to provide their statement. Because I think those are two distinct but equally important issues.
It's not rare for us to hear from somebody that restitution hasn't been ordered because it hasn't been picked up, like Fred said, through the process, so that the victim's right to restitution and the right to be heard are impacted too if it drops off the radar.
With the information that's shared on this pre-sentence report that moves forward with the individual, if they don't have the PSR, what is the HPA's documents that they use to help determine what sentence without the PSR?
Yeah, but a lot of it through the RAD, which is a reception, assessment and diagnostic phase of admission, right? It's self-reporting.
Okay.
If the guy says, no, I don't have a drug problem, and they only get a low level or no level of drug treatment, and he's a chronic, the treatment plan goes haywire as well as the parole plan. That's just an example. But the PSIs are also critical and important, and especially with sex offenders, you know.
Yeah.
So class C, D, and A's. Now, generally, we'll get most of the high category, high risk type who get a PSI, but there's time to evolve. But when you have the chronic and the class Cs or detrimental, dangerous drugs third, or even, theft stuff, you may not get a PSI, but just because they committed crime of theft doesn't mean they're a chronic drug user, you know, so that's what we have to dig. And sometimes we don't like to have to press into certain things in the minimum hearing because it should be all there, whether it's a police report or in the PSI. But the PSI would give you a comprehensive history to tell us about their character or their efforts to do pro-social things or their potential for supervision or not, you know? So it's a critical document for Paroling Authority.
Well, and I just want to say, and that's really good information for me. Glad I'm here listening to that. As a member of the judiciary, I will say again, I'm agnostic as to the results of this committee, okay? I'm just here to kind of help and provide information. But this subject that we're talking about right now, I think when we start listing out the reasons why the courts rather than parole board should handle minimum, I think this is probably at the top of the list, right? It's because the judge is in the position to receive all this information. The judge is in the position to hear directly from the victims, to hear directly from the defendant and any surrogates the defendant may bring to court, to see and understand the entire PSI, the police report attached there too, and you know, all of that. So that I think is probably something that we need to consider.
And we'll continue to discuss. Well, I have two more questions quick. Brandon, did you have something to say?
Sorry, no, I'm just unmuting myself. I have nothing to add. Thank you though. Appreciate it.
Yeah, I'm not jumping ahead to the eventual discussion about this, but the Paroling Authority gets the same information the judge gets. And with the added huge benefit of talking back and forth with the defendant, because that does not happen in sentencing. Often on the advice of counsel, they're not expressing remorse for committing the crime. There may be an appeal down the road. The attorneys are going to be careful about that. But in the Paroling Authority, they're asking about it. They're getting into the details. It's back and forth, and that changes the whole character of it. They get to know the defendant a lot better than the judge does. I mean, Judge Susan may have extrasensory perception dealing with the client that I do.
But Steve, the notion that I don't have a discussion with defendants at sentencing is false. The other thing too is if on the advice of counsel, the defendants are not making a statement at sentencing because of a pending appeal, by statute, the minimum has to happen within 6 months of the open term sentence anyway. So the appeal is still pending. So the same Fifth Amendment constraints are still in existence at the time of the minimum sentence as they are at the time of sentencing.
They still talk back and forth, and the judge talking to a defendant, it to me is not a discussion. I mean, I try to have meaningful discussions with them, but it isn't reciprocated by the defendant. It's not back and forth. You're not drilling down in the sex offense to what happened and what happened to the victim. That happens in front of the Paroling Authority. I mean, Cheryl?
Well, that is true. I mean, and especially with sex offenses, right? And judges, I think, are reluctant to talk about it openly in court. But I mean, Fred knows, I'll ask questions about what exactly did the crime, you know, how did the crime occur? What exactly the defendant did? But as to your point, I would say that if the PSI is waived, then you don't have access to that information as well. So the decision on whether to keep it with parole or with the judges are still, it's even, right?
Yeah, as I said, I'm agnostic on that decision. I'm just pointing out that I think oftentimes the judges are in a position to receive information. Because how often does the parole board hear live from victims at a minimum hearing?
Depends when they want to, and we either can have it in person or by video, depends on the facility and the conditions. And prosecutor's office, victim witness people participate in coordinating all of that. So victims play an important role in minimum hearing when they want to. Yeah, it's, minimum hearings is where they get full participation and acknowledgement, as well as they also receive consideration for reduction of minimum in in-person type hearings, yeah. But I did want to add on that the HPA also has pretrial records from misconduct serving pretrial time when they're at OCCC or in a jail facility. So that also weighs in when they have highest or greatest category of misconduct as indicating their behavior post arrest while they're being held pending trial and or sentencing, so there's a lot of additional information, but I, like you, think, oh yeah, it would have been great initially just for the courts to set it and relieve HB of the load. But I'm still on that in between, I'm looking at what's going to be the best and most efficient way to do it, but get the results that we're looking for.
Let's take one more question, then we're gonna ask Carl to move on. Go ahead.
Oh,
Erin.
pardon, can I? just
I'm
add?
gonna, Erin, and then you, okay?
Well, I was just thinking, maybe this is more common at this point, because one of my questions was what is in the PSI that's most helpful? And I think part of it for me is whether it's a PSI or records or some other information is what is the info that is most relevant to setting the minimum term? And I think what I don't fully understand is, some of the other information might be more related to treatment when someone starts their term. And so I think, and maybe this is more statute and law, expertise or to help me understand, but I think, I think often sometimes two PSIs are developed over time and they sort of evolve into these large documents. And I think it's even helpful for whoever authors the PSIs to understand what is the info in there that's most relevant to the minimum term, and then how do you present that information to the decision maker, whoever happens to have the minimum term. So I guess that's just a comment / maybe clarification I have moving forward to understand better.
Thank you, Erin.
I think we're missing one over here.
Hold on, real quick.
Okay, yeah, I just wanted to add to what Steve and Fred were talking about. When you talk to victims and victim service providers, they've pretty much agreed that the experience with the paroling authority is different than in the courts, and they feel comfortable in sharing. And it's not, there's kind of an understanding that it's much more formal and there's a distance when talking, but they feel comfortable in sharing what's been going on or their perspective, both victims and surviving family members, and they're comfortable with the HPA setting. So it's good to know the victim experience. I mean, we're informal, I haven't talked to every single person, but that's what we're hearing as we talk to people to try to gather.
They're more comfortable.
Yes.
Because it's not public.
Yeah, and that ability to share and feel heard. The judge has that role of being, impartial and may not be able to say thank you. I mean, they may thank them, but they don't feel that they were heard. It's something that the HPA can do in that way, and that's really valuable.
You're gonna have Miles.
There's a little problem that we have on the defense side. You go for the parole board, and victims often come there, either by Zoom or letter, but very frequently they're there, especially if it's a high profile case. They come before the board, to express their feelings about the sentencing. It's lopsided. The defense is not allowed to bring family members or witnesses to their side of the equation, the defendant's side of the equation, at the minimum term proceeding. And that's, a great disadvantage. I can understand why. Andy's here, Steve, the prosecutor's office across the state like the way the system works right now because it's a second bite of the apple without anyone saying anything to the contrary, other than defense counsel, piping up and saying something on behalf of the client. Meanwhile, you have the victim sitting there in the parole hearing, or excuse me, the minimum term hearing, crying crocodile tears about their case, and there's no balance to that. Whereas when I appear before a judge, whether it's a student or any judge, we generally have a fair playing field. We have one side of the courtroom filled with victim's family, Steve is seeing that, all of us, Andy is seeing that, and then the other side, we have other people who want to come up and say something about the character of the defendant. That to me is a fair proceeding, which we don't have, and we're deprived of when we go to the minimum term proceeding.
Right, but are there other witnesses for the government at the hearing?
At the minimum term.
Yeah, besides the victim, because otherwise you have the victim and the defendant, that balances it out.
And-
You don't have other witnesses, right? The state can't call other witnesses, so it's the victim and the defendant, both can be heard. Why is that an imbalance?
But if people, you're in court, an open court, and that both sides of the equation equally represented, I'd see that as fair. When I appear before the parole board, I just have my client, and then we have a prosecution that's already articulated with a maximum sentence or whatever. And then they have the victim there, with the victim with this advocate making another pitch. And I think that's unfair.
Or one to one.
We'll continue to make, thank you, Miles, for that information. Let's move on with the discussion. I thank you, everyone. Love the discussion right now. Carl, can we go ahead and move ahead?
Yeah, me too. This is great. This is exactly what I was hoping would happen. In fact, I think you've kind of gotten ahead of me in terms of some of the slides I'm going to show. But before I do move on, I want to just hesitate on this slide because we talked about judges engaging with victims, that last bullet. We've talked a little bit about some of the things around the first bullet. I haven't heard, should we explore the prosecution's relationship to victims? Is that something that needs to be lifted up a little bit here? As Pamela said, that's sort of the linchpin early on in the process.
Yes.
What, can you clarify a little bit what you mean there? Because I'm thinking, as I'm sitting here, I'm going, they're all separate parts of the system. The victim has a perspective, prosecutor, defendant, everybody's a different part. So I'm not clear what you're asking, but could you try to say it in a different way?
Well, and maybe it's just to kind of tie a bow around this part of the discussion, that the point of this section was to lift up what happens to victims and how they interact with the system. And you all have done a great job, and you've gone beyond that even in this conversation. But I haven't heard much, if anything, about, except for Pamela mentioning that prosecutors are sort of the central source of information for victims. And maybe that's all there is to say, but I just was wondering if there's more to say, maybe from the prosecution perspective in the room, about engagement with victims in the process and knowing what's going to happen with sentencing and that kind of thing.
All right, well, the prosecutors work with, at least First Circuit, work with our victim witness counselors, working with the victims. I've made it a requirement that the prosecutors either send a letter or appear at minimum hearings and at reduction of minimum hearings. At the same time, I've changed our procedures, so our prosecutors no longer appear at parole hearings because that's not our role. And, it's all misconduct or not in prison. So that's what the Paroling Authority considers. And this was not extremely popular with certain members of my audience, of my office, because they want to go to every hearing possible and relitigate the minimum. Essentially, they'd be going to a parole hearing and saying, don't let this guy out, he's really dangerous. And yet the Paroling Authority has certain criteria they consider, and that is not one of them. They've already considered that when they set the minimum, or the judge had a mandatory minimum. So they don't play any role after the minimum hearing or reduction of minimum. But we expect them to play a role there, work with the victims, enable that.
Well,
Can I say, just anecdotally, but I think my experience is probably pretty true across all of the judges handling these kinds of cases, at least here in the First Circuit. I would say well, first of all, when the PSIs are being completed, the probation officer who's compiling the PSI will always make efforts to reach out to the victim when there is a victim, like, DUI cases, PDD, drug possession cases, there is none. But in every other case, there's always a reach out to the victim to respond. And then, Steve's office does a great job of maintaining contact with the victim and asking the victim if they want to appear at sentencing. Anecdotally speaking, I would say in about 80% plus of my cases that I have for sentencing, the victims do not respond in any way to the pre-sentence report and or any request for restitution. There's just no response. And, you know, you can understand in a lot of garden variety C felony cases, they just want to move on. Especially if the victim did not necessarily incur a loss, like if the property was recovered at the scene or whatnot. I would say in another 10% of cases, the victims do at least take the time to fill out a victim impact statement. And so I can get their thoughts and feelings on paper. In only about 5% of my cases, and these are really the bigger ones, do the victims actually show up in court and make a statement in court. And I'll say this, it's always meaningful to me when they do. They always are thanked for being there in my courtroom. They are given as much time as they need to speak and to give me their perspective. And their perspective is always considered. So it's always appreciated when victims come to my court. I would like to see it happen more. They are always given a safe, fair opportunity to be heard and understood when they do come to court. It's getting them to come to court, you know, and I understand in a lot of these situations, people just want to move on. I understand that they don't want to have to do it, but it is appreciated when they do come to court and they do offer that perspective, and it is taken into account in terms of sentence. I can't tell you how many times after reading the pre-sentence report and just the paper, I've had one thing in mind in terms of the sentence. When the victim comes in and speaks, it's altered my thinking, oftentimes great on what the sentence should be. Okay.
I'm curious if we could get data because about victims appearing in front of HPA versus victims who come to court. Because what we've been hearing in our discussions at all the victim meetings, we bring this up, you know, to get people's feedback, is the level of comfort in going to HPA where there's not the defendant's family and where they feel like, I'm just repeating what they said, they feel like they're heard in a different way. Because that's going to be the impact, right? Is if we're looking at making a change and there's an impact on victims, is there some way to measure or get data about people being willing to come to HPA versus people feeling comfortable in front of the defendant's family in a different, very public forum to talk about their sexual assault or domestic violence or how traumatized they are as a result of the incident? I don't know, Carl, is there some way to pull data on that?
Well, Fred, is that true? Do you guys track that? Either of you?
Well, we have a record of all victims who appear at minimum hearings, so, but we have to manually pull it out. We don't have Aaron's IT type of capabilities.
Same for us. I mean, we have the judicial information management system, which tracks who's in court and who spoke in terms of the minutes. But we would have to extract that data manually.
Well, and they relate to notification as well too. Like if they're not notified because of the different systems, if they're not notified, then they won't show up with you versus, you know, it's a different part of the system. There may be a greater flow of information and time where people get to Fred's doorstep in a different way than both.
Yeah, one thing about to Judge's statement is that, you know, from what we see, generally it's that 80 and breakdown you talk about. The difference, again, and I'm just trying to be neutral, but I'm just sharing with you facts and observations, is that depending where we have a minimum hearing, whether it's in Palava, women's, in HBA's office, by audiovisual, we have victims who get very excited, very agitated, and sometimes would like to go through the television screen. And sometimes, many times, well, as part of our script, so you will direct your statements to the board, not to the attorney or the inmate. It's all to the board. Same with the inmate. Everything's directed to the board. But like I said, depending on where it's at and the type of offense and high profile or not, victims will, even if there was a plea deal, they'll act like if there was an extended term type sentence, you know? And,
Same experience.
yeah,
And,
so,
and I'll say this, sometimes, you know, in highly sensitive cases or volatile cases, I've had to have the sheriffs in the courtroom, multiple sheriffs in the courtroom for sentencing hearings where different sides are speaking, just to make sure that, you know, everybody understands we're in a court of law and people will act respectfully and accordingly. And I say that upfront and early. Steve used to say that too, right? And you know, but it is an emotional thing. This is an emotional thing we're dealing with. Look, I'm for victims being given the right to speak and be heard at every stage of the proceeding. This is the first time I'm hearing that, you know, there perhaps are victims out there who don't want to come to court, but will show up at the parole board. If that's the case, then we really ought to take a look at how we can make them feel more comfortable coming to court and providing them with adequate notice so that they can show up and say their piece, because they do have a right to under the statute.
because they won't say anything on the PSI or to the PO who's doing it. But yet, when we review the PSI, we prepare for the hearing, we get notice, victim wants to show up. What? So we're getting caught blindsided sometimes at the hearing with some of the statements that they want to make, and it's not even noted on the PSI.
I'm gonna take one more question or comment, and then we're gonna move forward, because I think we're kind of moving ahead into Carl's presentation.
Yeah, sorry, but just to expand on what's being said, because from the Second Circuit perspective, I mean, and from all the prosecutors' perspective, what's being discussed is really emphasizes the importance of the work that our victim witness assistance programs do, right? For us, I mean, our model is a victim-centered trauma-informed approach. It emphasizes information being provided to the victim from the very early stages of our engagement with them. It's why we spend so much time getting our information booklets and pamphlets and sitting down with them, not only to discuss things like crime victim compensation, but also this is the court process. This is the timing of everything. This will be when you have the opportunity to speak, to address the court at sentencing when we get to that phase. When they do get to that phase, we are in contact with them to discuss with them what format those statements can take. Do they need assistance in terms of understanding how to complete the forms for ACS? We will be there with them in court. They will meet at our Victim Witness Assistance Center. We'll walk them over to court. They'll be sitting there and supported by a counselor up until up and through the entire process of getting up there, speaking, addressing the court, and then going back to their vehicle when they leave the courthouse that day, right? And it's so important that you approach it that way, I think, because not every victim has the same approach. Has the same experience. That's what being victim-centered and trauma-informed, you know, you have to take into account, right? Not every victim wants to be there. But when they do want to be there, having that support system there, knowing that we're there for them to support them through the process, including at HPA, is important. And just one last thing, I know the statute requires notification and engagement when requested by the victim. In our office, it's mandatory. It's mandatory. That outreach occurs at the beginning, regardless of whether they've reached out to us and asked for it, so that we make sure we can keep them informed and supported.
Thank you. Go ahead, Carl.
Okay.
I think we're moving ahead, but I think we're good.
Yeah, this is great. And I think you've touched on many of the things that will come up. Oh, I'm sorry, I was muted. I'm not sure how that happened.
No, we heard you.
Okay. Well, this depiction is from the last presentation, just a sort of rough comparison of the different roles of the branches of government, and to highlight the judicial role. In Hawaii, the judge is determining what offense was committed, and the sentencing disposition, I think, is probably the main discretionary thing that judges are doing. There's some offenses that obviously are not eligible for probation at the top end of the system, but the basic choice about whether a person's going to prison or not is up to the judge. And then the maximum sentence is just set out in the law, and I guess the judge says it out loud, but it's not a matter of choice. And then there's this issue of mitigating mandatory minimums that we talked a little bit about last time, and I'll touch on again here. So the basic laws that are governing those things, 706-605 is about what the choices are. The main options are probation, prison, fine, community service, a compensation fee, and compensation fee and restitution are statutorily mandatory. There's this issue around sentencing of repeat offenders and the judge's discretion to reduce what is otherwise a mandatory minimum sentence when there are strong mitigating circumstances. I think Judge Souza talked about that a little bit in the last meeting. The probation eligibility is in 706-620, which rules out probation for murder and most of the Class A crimes, but it's available for Class B and Class C. And then the terms of imprisonment. And I have a question for you all. When you look at my screen, are you seeing the whole page? Do you see the whole page, or do you see my screen is blocking the right side of my?
No, we can see the felony grade and the mandatory max.
Okay, good. That's I can't, but you can. That's good. So that's the basic framework. I'm sure there's other, nuances that are out there. But again, there's the PSI issue. And I think a lot of the things that I was hoping to tease out on this page, you've already touched on. But this is sort of the rest of what's in those three statutes that govern PSIs, that it has to be ordered unless it's waived. What the contents should be. In 602, it's a description of the contents of the PSI. And in 604, the opportunity to be heard by the defendant and to get this information that's in the PSI. I'm going to hesitate there in case there's any more comments on PSIs, but y'all did a good job talking through that. Okay. As a lawyer, I wanted to sort of lift up the fact that lawyers are subject to a code of professional conduct. And maybe a lot of people don't know that who aren't lawyers, but I think it's an important thing to recognize for the rest of the group that lawyers have some pretty profound ethical obligations. On the defense side, well, on both sides, there's an obligation to zealously protect your client's interests. And lawyers really like that word zealous, but it's for real. I mean, that is a part of what's bred into being a lawyer is that fundamental, profound obligation. And there is a specific mention in Rule 1.2 of the defense lawyer's obligation to abide by the client's decision, and about what plea to enter, whether to enter a plea, whether to waive a jury trial, and whether to testify. Fundamental stuff that defense lawyers are dealing with. And also, I think it's important for y'all to recognize that the code of professional conduct for lawyers specifically calls out the unique role of prosecutors as a kind of a special species of lawyer, that they have profound obligations because of the role that they're in. They are obliged to see that justice is done, and they're obliged not to prosecute if the evidence doesn't justify it. So that's what that Rule 3.8 is. And again, I would open it up to see if the lawyers in the room want to embellish on this. I struggled to come up with statutory obligations for prosecutors and defense counsel. There may be things out there that I missed, but to me, this is sort of the floor, these basic ethical obligations of lawyers in the courtroom.
Go ahead, Fred.
It's a good point, Carl, because in the minimum hearings, when we have victims there, the order of presentation is first with the prosecution and then with victim witness. And before the defense puts on their arguments, will allow the victims to leave and recognize the defense attorney's obligation to his client, and the type of arguments that they'll hear may not be what they want to hear and will get upset. But we'll leave them that option to leave the room before the defense states their position and their argument.
We move forward, Carl.
Sure. Well, in both of these instances, the judicial process and the HPA process, we've got a little bit of data. This is publicly available data. And I just wanted to give you a little bit of an idea of the volume of what's happening in your system on these last couple of slides about the judicial process. So this is information that I lifted out of the last annual report that the judiciary issues, the 2022 report. Just again, so you have an idea of the scale. So there are 14,661 criminal cases pending in the circuit courts. This is all circuit courts. And in 2022, 4,011 cases came to some kind of termination. The clearance rate that I've listed there, and I can't see it, I know it's about 104%. Clearance rate means the number of cases that were terminated divided by the number of cases that came in the door. So a clearance rate over 100% means the court is doing a good job of keeping up with its docket. 100% would mean for every case that came in, a case got resolved. So this means that there were fewer than 4,011 cases coming in the door, just a few fewer. And that leads to a clearance rate that's a little bit in excess of 100%. So that's a sign of, a court that's keeping up with its docket, essentially.
I think part of with the pandemic, the number of cases grew, and because if courts weren't open, cases weren't being dealt with, they weren't topping, they weren't. So I think everybody's trying to catch up now.
Yeah. And
Carl, your 14,000 number, I'm assuming that includes people who are on probation or bench warrant status or conditional release or other cases that aren't necessarily pre-trial cases.
That's a great question, Judge Souza. I don't know. And I would have to ask the administrative office of the courts. I assume this was I would assume this just means open cases. But it's a great question. It didn't occur to me that it could include a case that's open because the person's already been adjudicated and is on probation.
Yeah, we don't have 14,000 pretrial cases pending statewide. I can tell you that.
Thank you.
Thank God.
Could be colleagues. Where are they? Where are those guys?
Not enough in that.
Well, and so that's a great example of how at this point, I don't understand what the data is telling me. And this is a great example of how when we do these projects, we do data analysis and then interact with stakeholders and get more clarity on what this really means. And so thank you. And frankly, I'm not too sure what to make of the next part of this page either, the type of termination. It struck me as odd that there's almost as many acquitted, dismissed, no prosecution cases as there are guilty, no contest cases. I don't know how to explain that either. Any advice from in the room? I mean, does that ring true to you all as well?
That does not ring true.
Well, I would say that, in terms of other dispositions, sometimes cases get dismissed pre-trial for various reasons, motions brought by defense counsel, whether it's Rule 48 or speedy trial concerns or other types of concerns. The other thing that may tick that number up is that when plea agreements are reached, sometimes defendants will plead to one or two. They may have multiple pending cases before the court. The agreement may include them pleading to one or two cases and the state agreeing to nolly prosecute 2 or 3 others.
Right.
And sometimes that happens. And so that may be part of the contributory factors to that number. I don't know without taking a deeper dive into that number.
Okay, that makes sense. Well, and I'm going to just
though, right? They're talking about cases. So that was my first thought is counts, but I think the data is speaking in reference to just cases.
But I assumed it was kind of like that because, like you said, there's 14,000. There's not 14,000. I don't know if they're counting each count as a specific case too.
Either that or the 14,000 number also includes, because it says pending criminal cases here. It could include the misdemeanors to the district court.
Well, we said circuit, but you're right.
Right.
Square feet versus 30,000 square feet.
I can look into it.
Yeah,
And bench warrant.
we have our
Aaron,
data
Aaron will,
analyst
I'll
here.
get clarity.
Aaron will grab clarity for us.
Go ahead, Fred, and then we'll move on.
Yeah, because sometimes, like in the initial annual reports, the previous years, they would show like we had 2,000-3,000 hearings. But really, it was those charges or cases that came before, but the actual numbers based on the individual was 400 or 500
Right.
and multiple charges. So the counting was a little off.
Well, and I think this page echoes that same issue where we're counting different things. The footnote here is important. The sentences were imposed on about 3,000 defendants, but it was in 2,900 cases, and there were 11,000 odd. And I can't see that number again on the right side of the screen. I remember that it's 11,000 and some change, but it's hard to understand how these numbers relate to each other. And even in the categories that I see here, there's no category for probation, which I assume is the most common outcome of a criminal case. It is everywhere else in the country, but that's not even listed. And I assume that probation is overlapping with fines and restitution, for example, in a huge way. But to me, this is kind of a letdown in terms of what the judiciary is reporting about what happens, because it's so hard to see what's going on. Okay, I'm going to move on. We've touched on a lot of this, but Mark, I'm going to ask you to just look around the room and see if there's more conversation about any of these questions that are posed.
Well, folks have the PowerPoint in front of you and the questions are listed. I know we talked about. Go ahead, Keldon.
Sorry, before, I don't want to beat a dead horse, but I was looking at the data online. I use the same data for preparation for my budget report, so I know where you guys are where you pulled the judiciary data. And I think the relevant column would be where it says filed. So in that criminal action sections, it said 3,865 cases were filed. I think that's more of an accurate number as to the number of cases that were charged across the state.
I agree.
Because I think that what they're looking at is that's the number of, and I think that 3,800 number is probably what we're looking at as far as generating the pulling circuit court case number. Because when you look at the district court number of cases that get dismissed, it's oftentimes a really high number because you take into consideration the cases that are arrest charge generated via a complaint in district court and then committed in circuit court, and then we dismiss the district court case if we indicted or information charge the case. Sorry, I just wanted to touch on that before, in case anybody else is wondering why the numbers are appear to be inflated. But yeah, that 14,000 number is probably all the pending probation revocations and all that stuff that's open during the calendar year when they run their query through the JEF system. Thanks.
Thank you. That makes sense.
If you're looking at those discussions, I know we had a lot of discussion around some of those questions already. Anybody want to add to those questions? Or answers to those questions?
I think just looking at that first question, you know, I think the answer there is it depends what information they have, right? If it's been a hotly litigated case where the judges heard evidence in motions to suppress, various pretrial motions, if the case was litigated all the way up to the moment of trial or even was settled during trial, they're going to have a lot more information than if it was settled in some sort of early disposition matter or very quickly after arraignment or as part of a larger package deal that maybe started in another courtroom but ended up with, say, Judge Souza because you happen to have the oldest case. Yeah, I don't know that that's an easy question to answer other than to say it can depend. I think judges can have a wealth of information and know a lot about a defendant or the facts of a particular case, or they can have what they get in the PSI if that case originated in another courtroom.
I think, though, even if the case goes to trial, what the judge is going to learn more about is the offense.
and know a lot about the offense, but may not learn that much more about the defendant.
I was gonna
When you-
say, I learn a lot about the defendants from the pretrial bail report. That
Oh,
initial
absolutely.
document that
PSI,
comes in,
yeah.
often tells me a lot about the defendant. So I'll walk even into the first court hearing at circuit court with copious notes about the defendant and the defendant's history, and it's not from any secret document. I'm pulling it from the pretrial bail report. So that's helpful to me too.
My experience in the system, I was a prosecutor, I was a defense attorney, now I'm a prosecutor again. And I can tell you the second stint of being a prosecutor after being a criminal defense attorney. Gave me a unique perspective because it was at that moment that it dawned on me that prosecutors and judges know the least about the defendant. It's the defense attorney who's in there working with their client who knows the most. But they have a responsibility that's very specific within the system itself, right? So the work that's done in terms of the social history, the PSI, giving, whether it's HPA or the courts, all that information is so incredibly important because I think Steve makes a good point. You learn a lot about the offense. But all this other information that comes through the bail studies and the PSI is what gives everyone the larger perspective. It's also up to the defense attorney to do a good job at informing HPA and the court about the aspects of their clients' lives that those respective organizations or individuals need to know in order to make informed decisions.
And I know this doesn't need to be said in this room, but just to say it anyway, there are good reasons why the judge shouldn't know too much about the offense variables itself. Because, the defendant may decide to waive jury, and I may be the trier of fact in the case, and I should not know too much about the facts and circumstances such that I've made up my mind before the case even goes to trial. So there are good and cogent reasons why judges purposefully don't try to find out too much about the facts of the case prior to the case going to trial. Now, in instances where there are motions filed and testimony about, like in a motion to suppress or a motion to dismiss, or where I have to hear evidence about grand jury testimony, I have to hear those motions and I have to take those facts and circumstances into account for the purposes of whatever motion I'm hearing. But beyond that, I should not be delving too much into the facts and circumstances of the case, the police report and whatnot, in the off chance that the defendant waives jury.
And I think one thing that we do have to recognize is we're not, judges are not automatons that, the same set of facts, one judge might put somebody on probation and another judge might send them to prison, regardless of, looking at 706, 606 or other things. That some judges are more tougher at sentencing than others. And that's always going to be the case.
Yeah, and it's always has been.
Always has been.
So Mark,
Yes.
there has to be a balance because you got a zealous defense attorney trying to do the best for his client, and you got a zealous prosecutor making strong arguments regarding the conviction and circumstances of the offense. But the only thing that provides some sort of objectivity for HBA's purposes is going to be the PSI. Because sometimes in hearings, we may have Miles just bombing us away. And we have a prosecutor who's presenting their case and, admittedly, Miles can make some very compelling arguments and almost convincingly. Almost convincingly. Nice left-handed. I love you. But, again, that's where, as a quasi-judicial body, which HBA is, you have to be able to sort it out. And like I said earlier, the PSI provides one of the most objective type of presentation of the individual's history, including those of the offense.
Can I ask a quick question? Like, because I know that you said that sometimes the parole board isn't able to get the PSI. Is that? Like, because I see it's in statute that it's required, so I'm just trying to understand, like, is that just a staffing issue or people, like, the courts don't have enough staff to put it together? Like,
I
what's
think it's all of
the?
the above. Because, just as an example, Third Circuit, back in the day, used to be pretty religious. And as staffing gets down and people get promoted and they move out, things get eroded and priorities get changed, the administrators change, their priorities change, budget changes, staffing changes. If you look at today, you look at judiciary, public safety, private sector, everybody's short staffed. I mean, it's hard to fill positions.
Right, if they don't get the PSI, it's because one was not created.
Yeah.
It isn't like it was made and it never made it to the parole, so it just wasn't done.
But it wasn't created probably because of staffing.
No, I don't think so. It's because, you know, maybe our case fell apart, so we make a deal for a misdemeanor and the judge is gonna sentence him right there. They don't order a PSI.
Okay.
Or for whatever the reason is. And it sounds like some circuits don't have PSIs, but it's because in almost all cases, it's not created to begin with. So they don't get it at the paroling authority. And it really is important. I think we all agree, it really is
It might be
important.
a procedural issue too, because at least in the First Circuit, if the PO is recommending imprisonment, whether or not the judge entertains that or not, an extra PSI is done for prison. So that copy is already made and sent to the courts. Now, the other circuits may be operating differently, and maybe that might be why Fred might not be getting it, even when a PSI has been completed. So I don't know about the other
Well, we'll make a
circuits, but
request. If we haven't, because we need to hold a minimum hearing within 6 months of admission. So if within several weeks of admission, we don't have a PSI, the clerks will start making inquiries to judiciary. And that takes time too.
Normally, doesn't the PSI contain also the closing report, especially?
Yes.
Big felonies? Yeah.
Yes.
You get a broad spectrum, you know, we get the supporting letters from the, plaintiff witnesses, victims, defense side, as well as the closing report that the prosecution office provides. The recommendation.
I would just add to the discussion that one of the problems with, the parole board getting the PSI too early is that sometimes when we come to sentencing, there are additions or corrections that are made to the PSI, or sometimes things are included in the PSI that should not be considered. And so we will make those corrections. Miles, you know, because he does such a great job at what he does, is sometimes he will have letters sent in on behalf of his clients that he wants the court to read and consider. The thing that we need to take into account is those letters don't get also read by the parole board unless they are appended later on to the pre-sentence.
Well, who's calling Miles? Because he turns them in so damn late, you know, and there's multiple tabs and everything. But eventually we do get there.
You like my tabs.
So, you know, that's the one thing is that I think there's a window of time where the PSI and all of its updated attachments probably should be sent, because then we're all working off of the same document.
Miles, what would be the decision-making process for the defense to waive the PSI?
It's pretty rare, unless it's a misdemeanor and you get an indication from the court. And a lot of us, you know, and Henry and I have similar feelings about this. We kind of read our audience, right? Don't go where you're not invited. If the court's indicating that they're satisfied, they understand the facts of the case, we'll waive the PSI. But that's pretty rare, especially with felonies.
If the defendant's gonna go to prison, there's almost no incentive to waive the PSI because the
Correct.
defendant's gonna sit anyway. Where I see the defense really pushing to waive PSI is in a probation agreement where it's credit for time served. Yeah. See, the PSIs take about 3.5 to 4 months to generate. Okay, that's the turnaround time. And that's fast here in Honolulu.
90 days is on the fast track.
Is way fast. In fact, they give us the date. I can't. So if I take somebody's change of plea today, I'm setting their sentencing today in mid-February to late February. Okay, the reason for that is, if I set it any sooner than that, I'm not gonna get a PSI. So, so when you take into account a defendant who has made a deal for probation with credit for time served, jail at the time of sentencing, yeah, then oftentimes the defense attorney will say, Judge, well, you have a Rule 11 agreement, you know what the parameters of the agreement are. I'm gonna ask that you sentence him right away, because I don't want my client to have to wait another 4 months in prison before they get sentenced, just because we're waiting for the pre-sentence report. Now, I will say this, in almost all of those instances, I say, nope, I want the PSI because I want to make the best decision possible. Also, there's issues oftentimes of restitution. And so if I'm gonna sentence somebody right away, what I have to do then is make sure that I also then set a further hearing 3 or 4 months down the road. So at least a restitution study can be done to determine whether restitution is available and appropriate to the victim. Why? Because if I sentence them right away, I don't have any, and the victim's not participatory at that point, which they normally aren't, I don't have any information at your risk.
When there is a waiver, it's always, because the court always asks the prosecution their position.
Yeah.
Everyone has to be on the same page to have the waiver.
If it's a Rule 11 agreement, no, not per 706-601, but if the prosecution says, no, I don't want to go forward, my default is, I'm almost always not. Because oftentimes too, that 4-month period of time, the defendants hate it, but it's valuable time for them. If they're gonna be placed on probation, they're gonna have to do drug treatment. And so if you're sitting in custody, you should be applying to the treatment programs. And so that time between change of plea and sentencing is often valuable time for them to apply to or to get accepted into drug treatment. And if they get into a residential treatment program prior to the 4-month wait for sentencing, I will supervise release them pending sentencing through the program. I think it's only fair in most cases. So if they cut a deal for credit for time service.
And just so people know, it takes 8 hours typically for a probation officer to prepare the pre-sentence report. That's about how long it takes. That's what shows.
Yeah, and because there's a lot of value right there. In the First Circuit, we have a great team of probation officers who compile those pre-sentence reports. I often call them to thank them because the information that they include is really, really important and really valuable.
And similarly so, we'll continue minimum hearings. We don't have enough or proper information to render a good decision or a good minimum.
Yeah.
I have to say that I really appreciate, we could clone you. That I think it's important to, having been on the Penal Code Review Committee before and the Justice Reinvestment Committee, that I think it's important to note that that's not happening throughout the system. That I'm really glad that like I said, I really appreciate your sensitivity to victims and that you're thinking of them, because I tell you, as victim advocates, our experience through the decades of doing this work is that victims are invisible. Like this resolution, the only reason we're here is we had to argue to be on this panel, that when this legislation started, there was no victim representation. So the victim's voice would not have been on this, and that happens really a lot. But I think it's important as we think about this to know that while I feel like you're talking about best practices, that when you look at what's going to happen and the decisions are going to be made, that we know, because we hear this all the time too, and it's come up at Penal Code Review legislation, panels before too, is this issue about it's very convenient for courts who are busy on other stuff to go ahead and waive PSIs, which excludes victims and restitution. So I understand what you're saying completely and appreciate it, but I think that what Fred is saying is true and what we know is true is that's not how it looks across the system for
and I appreciate being here and hearing that perspective. That's valuable.
Thank you.
Thank you.
Thank you everyone for that. Carl, can we want to move on?
Yep. Okay, well, we've touched on the HPA process already a fair amount, but let's dive into it. Pardon me?
Let me get one more question. I didn't see
sure.
Kelvin's hand.
Thanks, Mark. No, there's been a lot of mention about the Third Circuit, so I figure I'd just share something really quick. So a lot of people were talking about how we, at one time, it was a very common practice to waive PSI on prison cases. That was something that was addressed a couple of years ago. And I'll be honest, one of the reasons why that was such a common practice, I think Miles touched it a little bit about, like, you know, working with defense counsel and settling cases. But one of the other things, large consideration, is that the PSI turnaround is 8 weeks. At one time, it went up to 12 weeks. So if you've got a guy who's been in custody for a long period of time, and it's a deal for, like, he's gonna take an open 5 on like a prodang third or a para or whatever it was at the time. The thought was to try to get him sentenced so that his status would change so that they could ship him out and he would get out of HCCC, because as we all know, I mean, as Kristen's been working on, it's very overcrowded. So that was one of the other considerations that I think prosecutors, defense counsel, and the judiciary were taking into consideration. Since then, we've moved away from waiving on prison cases because Fred and his team have indicated their concerns about not having a PSI available. We still routinely waive on probation cases because the offender will be placed on probation, and we've got to make use of the very limited resources that we have here on the island. I think it was mentioned earlier that we do have a PSI team. On the east side of the island, that's 2 POs. That's it. So imagine all your felony circuit court cases going through 2 POs to do PSI reports. Another thing was mentioned, I heard Miles reference about HPD closing reports. Here, Hawaii Police Department doesn't do a closing report, so it's not as easy for prosecutors to just slap that closing report, attach it to the PSI input and send it in. It's really important for our prosecutors to take some time and actually generate a prosecutor input. And we also rely upon our assigned victim advocate to reach out to the victim and obtain a victim impact statement if possible, so that it can be included within the PSI. But you know, now that with the closing report issue, maybe that's something. I think it was good that Miles brought that up. I'll try to talk to Chief Ben about it to see if that's maybe something we can do on our island. And talking to the police department, maybe we can get our detectives to generate a closing report in those more serious cases with the CID, with Criminal Investigation Division. And I'm glad that we're remembering to focus on victims, because victims' voices are important. And a lot of times people come and call prosecutors up and they say, "What about the victim?" So I'm glad that voice is being echoed here today. But thanks for the opportunity to share about our island.
Thanks, Geldin.
I think, and I understand the staffing issues in HCCC, but it's often really important in probation cases to have a PSI, because then the probation officer has all this information to work on when the defendant is motivated to be honest as much as possible and talk to the PSI writer. So later on, when they're on probation, if it's all self-reporting, it's a tough job, I think, for the POs to be supervising folks. So,
Okay, Carl. Thank you.
We're going to dive into the HPA process a little bit more. And again, this diagram from the first presentation of what's going on with the executive branch. So the HPA has both. And again, I'm handicapped by not being able to see my own slide the way this is set up. Let me see if I can move that. Here we go. So the HPA generates standards. They've got this document that describes the standards that they're operating under to set minimums. They have the hearing for the minimum, and they have the power to change the minimum. And Fred has mentioned that. And then in addition, they have the parole release authority, the revocation authority, early discharge of parole is a possibility. And clemency, taking part in the clemency process. So the statutory framework for the HPA, the general authority and duties are set out in 35362. So there's this laundry list. It's actually kind of interesting. This list doesn't include anything about setting the minimums. It's a list. It purports to be a general list of authority, but it has everything except the minimums, and the minimum process is set out in a separate statute that we'll get to in a moment. But this is, I'm sure, familiar to Fred and others. the basic things that the paroling authority is supposed to do. Including things at the top of this page about interpreting the parole program to the public, maintaining records. The very last item on this list is something that jumped out at me. And Fred, I wanted to ask about this. Unusual to have a requirement that you file a report with the governor every 3 months. Is that, and I haven't experienced that anywhere else. Is that something that you all are on top of?
Of course not.
Well, it struck me as a bit onerous. I mean, that's very unusual to have something like that. So I wonder if that makes sense to have an onerous requirement that's impossible to satisfy.
If I recall right, that part of the statute originated when the Republic turned to a territorial government back in the early 1900s.
Wow.
And it has never changed. Now, 7 years ago, when I first came on board, I said, how the hell are we gonna do this? But we're gonna use our annual report. We've made modifications with the help of one of our board members. We've made it a little bit more robust and informational, and we'll use that as the annual report to the public and to the governor.
Right.
So to do a quarterly report is a little bit insane, especially when we don't have the technology or the ability to pull numbers. And right now, everything is having to be done manually with 3 staffers.
Yeah. Well, I suspected this must be an impossible mandate to satisfy. So I appreciate hearing that. And then there's the actual separate statute, 706-669, that describes the procedure for determining the minimum term. 6 months deadline, and I understand, Fred, you've mentioned that this is usually more like a 4-month process, I think. But 6 months is the outer limit. Getting a report.
We'll try and schedule minimum hearings within 5 months of admission. But depending on receipt of documents or the defense attorney's motions, we can continue beyond that.
Yeah.
Now, we do have one extreme case, which has gone on for 12 years without a minimum.
Oh my gosh.
Yeah, and it's been through firing attorneys, defense attorneys, not satisfied with the counsel. Plus the guy's a little bit off, but he still passed the 404. But it goes on and on. It's a rare case, but you know.
I was gonna say, one of the exceptions to that, which Fred is alluding to, the 6 months, is that if the defendants or inmates who are sentenced to prison on one case have other cases pending, right? And you guys don't take action. You wait until all the cases are resolved before you set the minimum.
So it's come for this particular case, we were going to set it anyway and let the defense attorney, who we have been in discussions with, follow Rule 40 if they didn't like the outcome of the minimum. But we're talking about multiple sex offenses. I think he had 16 or 20 sex 1 and sex 2. It's a lifeline, but he's got nothing to lose by delaying it. So, but these are those extreme cases that we encounter.
And while we're on this page and you're speaking, Fred, I wanted to ask you to comment on the third entry on this page and whether this is something that is just in the statute or is it something that is invoked with any regularity? This idea of a special condition that the person will not be considered until they have a continuous record of continuous exemplary behavior. That really strikes me as an unusual clause, and I just wondered if that's something that is put to work, or is it just there on the books?
Oh, it's in the books. It's put to work. But there's numerous exceptions to the rule. But that particular writing, again, has been in the books since the early 1900s, when the Board of Prison Directors would go into each facility based on the previous King kingdom's mandates and or the provincial governor's mandates to go in, inspect, and look for individuals who displayed exemplary behavior and were deserving of early release or being paroled and or being pardoned. And that's in the research. So as far as the current board and how we look at exemplary behavior is misconducts, their accomplishments as far as completion of abuse, substance abuse program, or sex offender programs, or parenting, or domestic violence, and so forth. So the combination of all is critical when we do the review. Now, we did start something, and Corey Renke, who's the acting division head, has been going to the different facilities to do pre-parole type classes. We came up with a parole guideline last year in concert with Max Otani, was director at that time. And now Corey has implementing it, and they're now planning a trip to go to Arizona to hit all facilities at one time or another, and all inmates should be covered who are entering that phase for pre-parole. So they've had fair warning about being good boys and girls.
Can I ask you a question?
Sure.
When it says continuous exemplary behavior, like, and I know that it varies by case, I totally understand that, but is there like a general time frame of like misconduct, like is 6 months impressive to you, misconduct free, is 3 years, like, is it, I'm just curious.
Case by case, because you have some people who are really violent. And sometimes we'll say, look, you're in close custody, if you can get to medium custody, and you can be 1 year free of high category, greatest category misconduct, to consider parole to an appropriate facility or program or what have you. So exemplary is kind of nebulous, for lack of a better word. But I mean, you don't have to be, you know, a Boy Scout from day 1 to 10 years or 20 years.
I guess what struck me about it is that it's maybe the same kind of question as Kristen's, but it's so the open-ended nature of this sentence. Are you still setting a minimum for these people, or is it just sitting there?
It's set.
Pardon me?
If we're looking at parole consideration, we're looking at exemplary behavior based on the institutional performance from the time of commitment.
So Carl, this part of the statute refers to when the inmate will be considered for parole.
Parole,
Not if their minimum is gonna be set.
Okay, that makes sense, but I wasn't sure that that's how it was understood. I appreciate that. Well, here's another mystery. This is a screenshot of some rules that are, I think, on your website, and that the rules that are specific to minimum setting, quite dated. I think this is well, I can't remember. Well, adopted in 1991 is what it says. This is the only rules that I could find in Hawaii about minimum setting, but they're not on the. There's a website that has all the administrative rules in Hawaii, and it has a section for the Department of Public Safety, and there's a handful of issues that are covered on that website. This is not there. And I'm not even sure this is a real authoritative document. So can you help us with that?
Yeah, so the Hawaii Administrative Rules governs the setting of minimum, and it's authorized by statute.
Right.
Statutes, I think, from 35362 on, but that pretty much holds almost as a legal statutory requirement, but that has not been updated since 1989, to my knowledge. And initially, when it was Georgiana Ewan and Judge Foley at that time, Dan Foley, they worked together to create that first set of administrative rules. We've tried to get updates over the last 20 some odd years, but we have to rely on the Attorney General's office, and they've got 1,000,001 things to do too. Because the current admin rules also reads that there are 3 individuals who sit on the parole board, 2 part-timers and 1 full-timer. So I mean, that's all archaic it is right now.
So I guess I'm not clear. Is this document that's on your website, is it a controlling set of rules?
Yes, it is.
Okay, okay. And then there's the actual guidelines themselves. I think we talked about these and certainly looked at these a little bit in the prior presentation. The statute requires the authority to establish these guidelines. They have the 3 levels, and I'm referring to level 1 as mitigated. That word does not appear in the guidelines, but the effect of the guidelines is that there's a middle tier and then there's a lower end and a higher end.
And the minimum guidelines came about from the JRI, which Council of State Governments participated in, I believe that was 2012. And the end result was that development of the minimum guidelines. The guidelines were established before that, but the GRI to help firm it up, as well as with other things, to improve supervision and increase the board to 5 members instead of 3. And we got increase in parole officers, but I think one of the recommendations early on was to have a standardized setting a minimum terms and conditions.
Right. And I think, if I'm not mistaken, and I could be, the text on the lower right-hand side of this page reflects the changes to the guidelines, or the nuance to the guidelines that came out of the JRI exercise. That those 5 bullets on the lower right are
Right.
newer features of the guidelines that are part of the thought process. Is that right?
That's correct.
Okay, great. And here's the actual, what the guidelines indicate in terms of setting minimums, pretty broad ranges. I think that we showed you this slide the last time, if I'm not mistaken. But these are just the sort of numbers that the parole authority is operating under to set the minimums. And then I wanted to touch, we've gotten into this a little bit, but to touch on to circle back the role of the defendant, the defense attorney's role and the prisoner's role versus the prosecution and the victim's role. And the statutes actually cover these. This is 706-669. Part of this long statute, the procedure for determining the minimum, sets out these entitlements essentially to participate in that process. So I wanted to stop there and see if there's I know we heard a little bit in the first meeting about what this looks like, but I wanted to open the door to some more of that input. Mark, I'm hearing none. Is that?
Yeah, we can go ahead and move forward. So.
This is the issue that Judge Souza raised at the last meeting that I wanted to at least flag again for you all, that to date, there's been a handful of cases, unpublished opinions by your Intermediate Court of Appeals that and I have to beg your pardon, my dog is making me nuts here. I'm going to walk around while I talk and let him outside. But this is the issue of the right to a jury to determine facts that affect the range of punishment. And in cases around the country and in the federal sentencing guidelines, that line of cases, Apprendi is the original one. Those cases have held that determining facts that affect the range of punishment, either at the minimum or at the maximum, that a defendant is entitled to a jury to determine those kinds of facts, at least entitled to get to a jury if they want to. Of course, in many cases, that right is not invoked. But the right has to be upheld so that people have access to a jury to determine that critical feature of the minimum punishment and the maximum punishment. Your Court of Appeals has sort of sidestepped that requirement, I would say, because this statement here on the right is the logic, which I find a little bit unpersuasive. But again, in deference to Judge Souza, I just wanted to flag this issue one more time and see if there's any commentary on this.
Well, I'll make a comment one more time. I think that in my mind, this is one of the big issues of shifting, potentially shifting the role of setting minimum sentences from the board back to the courts, because we do have this body of case law, albeit very thin, from our Intermediate Court of Appeals, basically exempting what the parole board does and the considerations they make. Not so much from the Apprendi process, but from the Alene process, which is basically setting what amounts to a mandatory minimum sentence, right? And so what Alene says is that any fact by law that increases the penalty for a crime is an element that must be submitted to the jury and proven beyond a reasonable doubt. Mandatory minimum sentences increase the penalty for a crime. It follows then that any fact that increases the mandatory minimum is an element that must be submitted to the jury. Now, one could argue, and I think rather persuasively, that if the court set a minimum amount of time where you must serve jail before you're eligible for parole, one could argue that that's a mandatory minimum. And right now, if you look at the process that's set forth by the parole board in terms of their guidelines, they are taking into account in setting the parole minimum offense variables, including the nature of the offense, the level of the defendant's involvement in the offense, and under federal case law, if the courts are, which are not subject to the ICA case law, if the courts are now going to be setting minimum sentences based on our determination of the offense variables, wherein the defendant has to comply with that before they're eligible for parole, do we at that point run afoul of federal case law? Because we don't have the same protections currently in place that the parole board does. So that's a concern to me, and I know that we're going to look at the way other states do it. Other states have kind of gotten around it, you know, by promulgating guidelines and whatnot, which I know we're going to talk about, but that's an issue. That's an issue that we need to take into account before we just reflexively say, okay, let's rip this function away from the parole board. Right now, they do enjoy a certain amount of protection that the courts don't necessarily have.
And I guess, thank you, Judge. What strikes me is that what's happening with the paroling authority is sidestepping this constitutional requirement that people are entitled to a jury to determine facts that determine the level of punishment. So I guess I mean, so far the courts of appeals have upheld the process, but I personally don't find the arguments in the Court of Appeals all that persuasive. It seems like Hawaii has sort of sidestepped a constitutional requirement by changing by giving the paroling authority this power to set the minimum, so the courts are insulated from it. So to me, it's a question about the current process as much as it is about what if we change it to a judicial process. And in the states that have more typical judicial sentencing, they create they've set up some rules so that people have a right to get to a jury, and it gets invoked in 1 out of 1,000 cases. It just doesn't really happen very often, but the right is there, and there's a process for people to accomplish that right It's just it's like a jury, it's like jury trials in general. It's just not a very commonly invoked right.
Yeah,
So-
and the way that federal case law has evolved is that it's either, facts that are determined by a jury or pursuant to the Blakely case, or are admitted to by the defendant,
Right.
right? And so if we are going to start adopting this process where the courts are going to be then setting these minimums based on offense variables, our factual basis for each of these cases is gonna have to be much, much more detailed.
Right.
And sentencing is gonna be or could potentially be a much more long and involved process.
Well, and the way this came about was if somebody is getting like a 20-year term and they have multiple felonies, it's the judges were given the authority to increase that 20-year term for extended term or something like that. And so they said, that's not fair. If you want to do that, the jury has to decide it beyond a reasonable doubt. So it's extending this mandatory term. I think, was Apprendi a hate crime deal or
Yes.
something?
Yes.
Yeah, so
Apprendi was a hate crime, Aline was a gun crime, where they said, well, you committed this offense and you had a firearm, so we're gonna bump up your mandatory minimum. But the fact that the defendant had a firearm was never found beyond a reasonable doubt by a jury.
So like for an extended term, we have to give notice of it, and then the judge has a trial and then tells the jury, you're not, in some cases, you're not quite done, and then you have an extended term sentencing procedure on that to extend the maximum beyond what it would have been otherwise.
Yeah, and so that's why I said
It's only a recommendation.
Right.
Terms are, it still puts the authority, discretionary authority with the court.
Right.
Which is.
And I think that because they didn't want the jurors to feel guilty about doing this, and they give it back to the judge.
I don't, you're right. I don't want to get, that's why I said, I think for the purposes of our discussion here, the whole Apprendi discussion, or as it relates to state of Hawaii case law, state versus Kaua, that whole, or Malgautega is the other case. But that whole extending the sentence beyond the maximum, for the purposes of our discussion, I don't think is really relevant. What is relevant though is the Aline conversation, because if we're setting minimums, the court is setting minimums based on offense variables, and that's gonna ultimately be considered to be a mandatory minimum, then we do run afoul of federal case law. So, okay, go ahead.
Well, and again, I find the current process suspect under federal case law. That's what I'm saying, is that just by giving it to another body of people to make the decision, that where there's, again, no right to a jury, to me, that still runs afoul of a lien in particular.
Right. So, one may posit that, well, we have the legal cover currently in place, so maybe
either way,
leave the system as it is. But I mean,
that's the spirit.
All right, moving on. So again, I wanted to just lift up what data points that we have available. This is information derived from the reports that HPA promulgates, and my colleague Angie here at the Justice Center did some work looking at some of the reports over time. So again, first of all, a sense of the volume. The cases, then this is everything that comes before the Paroling Authority. There were 4,000 cases. That was kind of the high water mark in 2019, and about 3,000 in the most recent year that we have the data. The parole release decision itself, those cases outnumber all the other things the HPA does by a lot. They're by far the biggest category. The minimum term hearings were 16% of the caseload, just counting cases. But I think we've heard from Fred and maybe others that anecdotally that in terms of the actual workload, it's more like twice that. It's more like a third or 30% of the workload of HPA is around this issue of minimum setting. Is that fair, Fred?
Yeah, early on, I think about 7 years ago, it's thought about 30%, but I would say more like 20-25% of hearings. It doesn't mean that the board members spend less time preparing, because minimums take the most time in preparing.
Right.
Yeah, so the parole hearings itself are high in numbers and maybe increased only because we've adopted a different position as far as what we call short setting of cases. So rather than deny and come back in 11 months and the person does dead time, if they're gonna finish a program in 3 or 4 months, we'll short set it and come back in 3 or 4 months rather and make a parole decision at that time.
Right.
So that actually increased our number of hearings by about 30% itself.
I see. But it's a way to be responsive to people's progress as they in the system, right?
Progress in giving people opportunities for parole out in the community.
Yeah. Okay, so the second half of this page is just kind of toting up the minimums that have been set for a handful of common enough crimes that there's enough of an end to do the math. So these are average minimum sentences across the listed major offense categories, and over a span of time. So what's striking here is that the numbers, these averages that you see are right around the dividing line between level 2 in the paroling authority's guidelines and the bottom end of level 3 in the guidelines. Does this ring true to you, Fred?
Pretty much so. I mean, it looks about right because their averages is a necessary range that we deal with. And the range would take into consideration the seriousness of the offense and the individual offender versus, I mean, you could have 2 individuals for sex assault in the 2nd degree, but one get a much lesser minimum than another one in the same crime category, I would say.
Yeah.
And there's individual reasons for the low setting of minimum versus the high setting of minimum of another one.
Yeah. And again, this is means, average means, as opposed to medians. And I think I would be curious to see this same data point as a median, because big numbers pull up the average, of course, and a median is the midpoint. So that might be something we can explore down the road.
I think it should be pointed out that Class A's, typically the judge gives them the open term, right? It's mandatory, 20 years on Rob 1s.
Other than for manslaughter and certain drug crimes.
Right, but for B's and C's, most people get probation. So the only ones getting sent to prison are the worst ones. And the paroling authority is looking at the person's history too, of other offenses and everything else. So it's not, it's not like everybody with a Class B is sent to prison and this is the average. You're only getting the top slice. It's rare for somebody to get an open term on a B or a C if it's not mandatory or repeat offender.
Right.
Does that ring true for Maui and the Big Island?
I think, generally speaking, yes. I mean, it depends on the offense. I mean, I'm assuming too that the only offenses considered for these averages are the ones that are in the parenthetical, right?
Yes.
So obviously there's other offenses outside of that that may be treated differently, but I mean, these are the most serious offenses, right? Assault, home invasion, sex assault, PED second. It leaves out negligent homicide, but
Thank you. Carl, are we moving forward to the discussions?
Yep.
A lot of our discussions since we started has touched on these questions. Yeah, but let's as a group take a look at those questions. Just gonna go ask real quick, Fred. Has HBA set a minimum higher than a judge recommends?
Of course.
Well,
Not always.
what's that look like?
Well, on a repeat offender, for example, they may set it at a 3-4 or a 1-8. And if the person was recently admitted, but either had pre-trial time or probation time, they may have credit for time served. and they could have already exceeded the court's minimum. Yet not having completed any substance abuse program or sex offender treatment or anything else. But their history, okay, may warrant, based on our guidelines for minimums, may warrant a higher level of punishment, maybe a level 3, for that class and, or for that offense or the individual, and he has a completed program. So individuals can complete their minimum or even a court minimum, because sometimes we'll be spot on with the court minimum, but they haven't completed any programs and the credit for time served put them outside the minimum, making them eligible for parole. So it's, you know, we have so many different type of individual cases that fall in that category.
And on the average case, a judge does not set a minimum. He gives them 20, 10, or 5. If it's repeat offender, that's the most common time a judge will set the minimum, but that's a small percentage of cases compared to the overall. Most of the time, judges do not set minimums.
There are only 4 situations in Hawaii where judges can set a minimum, a mandatory minimum sentence. That's repeat offender. That's crime committed using a firearm or semi-automatic firearm. That's involving the nature of the victim, elderly victim, very young victim, disabled victim. And then the other one is when it's prescribed by statute, for example, habitual property crime carries a mandatory minimum of 1 year. So other than in those 4 instances, the courts are sentencing people not to mandatory minimums. But when we do sentence someone to a mandatory minimum, it's prescribed by the statute. So for example, if Fred says I'm sentencing someone on a C felony to a 1-8 mandatory minimum, that's not my choice. That's what the statute requires me to do.
It isn't, because not that Judge Souza does it, but we've seen cases where the judges will reduce the mandatory minimum because they got a big calendar too. What will it take to shrink down my calendar? So I'll give away the farm from prosecutor's perspective. Sorry, Miles. They'll give away the farm to reduce the mandatory minimum, and they'll say, we'll take it up with HPA.
But that's,
Yeah. You know, in those instances, though, you have to be very careful when you colloquy the defendant, that the defendant understands that, you know, while the court may find strong mitigating circumstances to reduce the mandatory minimum, and I do so rarely, but when I do, you have to be clear with the defendant that the parole board gets the final say. And whatever the parole board decides the minimum is, that's what the minimum is. That's the one they have to do. And if they're not willing to understand that, then I can't take it.
There's an unknown variable that drives people from trial, not to plea agreements.
Yeah, I mean, and again, my first reaction when I saw this task force created was that, you know, was the opposite of Fred's, which was, you know, well, you know, this will help give me leverage to resolve cases because I can give them a definitive answer on what the minimum is. But then when I delved into it a little bit more and I looked at some of the case law that I cited earlier, as well as some of the other issues, it's one of those situations where not so fast. There may be unintended consequences here that could be very problematic that I think we need to discuss.
statutorily, constitutionally.
Yeah.
And uniformity and consistency too, right? Just
Right.
like everybody across the
Absolutely.
state. The counties all kind of take their cases a little differently. Maui had a great reputation for being the hammer. Judge Liu would just pound people, whereas the open 10 in Honolulu, it's hard to come by. Because everyone, by and large, gets probation, like Prosecutor Alm said, so the HPA really is geared up to have that consistency and avoid unwarranted sentencing disparities.
You have 32 different circuit court judges statewide, and here in Oahu, not all of them do crim matters, but on the neighbor islands they do. And so, you know, if you have a purely indeterminate sentencing system where the judges set not only the minimum, the maximum, but also the minimum, you may get 32 different answers as to what the maximum and minimum are. And the attorneys know that. It's gonna invite forum shopping. And there's, you know, as an attorney, it was my main job to know what a particular judge was gonna do with a particular case. That was my value, was predictability to my client. And so the attorneys make it their business to know they study each of us, and they know, and so, but we're not all the same. We're not. We're all different.
Well, like I said earlier, a lot of the questions on this particular discussion slide, we talked about in the last 2 hours. I want to apologize. The discussion was so really deep, time flew. So I want to kind of finish it because we have maybe 40 minutes to go instead of taking a break. Because I think that we're all engaged at this time and present. And I want to make sure that we can get Carl's PowerPoint presentation done. And then at the end of the presentation, we'll talk about the future meetings that we need to be having for next year. But Carl, we can go ahead and continue, please?
You bet. Thanks, Mark. Well, and you can see now we are approaching the end. There's not nearly as much detail in the next handful of slides. I did want to touch on the corrections agency's role in all this. And what I did, there's a ton of statutes that govern what happens with corrections. There's a long list of things. And I just tried to pluck out what I thought were probably the things that the chapters and the pieces of the law that are the most relevant to the attempt to rehabilitate people and so forth. So that's really, I don't have much to say about this slide, but chapter 353 is a lot of it. And this is, and it's now correct, or it's going to be corrections and rehabilitation when the law changes in effect on January 1. But there's a whole slew of things that are mentioned and spelled out in statute under chapter 353 as indicated here. This is just a sample of some of the topics. And then there's several other add-on statutes, whole chapters that have to do with the way that the agency is trying to handle people under its custody, treat them, reentry, and so forth. Difficult to go into any detail on these, but certainly worth being aware of. And Tommy's not there, I guess. This may fall a little flat, but we had a meeting with Tommy when we were on the island a couple months ago, and learned a little bit more about what happens. And Fred, I'm sure you know about this too, but what is it? What is the staff doing to staff up for these minimum hearings? How does that affect the workload within the corrections agency, as well as the staff of the Paroling Authority itself? And so on. I'm gonna stop there and see if there's any reaction to any of these questions.
Well, there's a slight increase in workload whenever you have new admissions, because any individual, once they convert from jail to prison, have to go through the RAD assessment process and deprogramming. So for the case managers, well, a lot of them are trained in doing the LSIR. And if it had one had not been done previously, they'll have to go through that, do the assessment. And if there's a PSI, review that and create what they call an IPP, or initial prescriptive plan. That IPP goes to the board for minimum hearings. So that itself takes a little bit of time for each of the case managers who are assigned to the new admission. It comes in spurts, and Neighbor Islands is different from First Circuit in Honolulu as far as the admission rate. But, that minimum is not necessarily a severe increase in workload, only because it has to be done in the first place, as far as prison admission program. And we always say intake begins at admission. Rehabilitation begins at admission, so does programming. So it's not an additional amount of work. It may be for ACOs or guards to move bodies to bring them into hearings. Or if we're doing it by audiovisual with Zoom or Teams or Polycom, it's just a matter of moving prisoners, which they normally would do anyway. But we don't impact all facilities the whole month, because we do go to Halava maybe 4 times a month, women's 1 to 2 times, OCCC 1 to 2 times, Halava more, Arizona about 4 to 5 times a month, audio visual. So we're not severely impacting the workload for minimum hearings, yeah.
So what's the average hearings a month
For,
for everything, every facility seen at least once a month?
oh, so for those, we're looking at minimum hearings, parole considerations, parole revocations, parole reconsideration, sometimes program determination for sex offender treatment. Probation, parole violation reconsideration. So we're looking at 400 plus a month, 5 days a week. Split between 4 part-timers and 1 full-timer. So it's, you know, you're averaging about anywhere from 15 to 20 a month, some days lighter, some days heavier.
15 to 20 a day.
A day. And then at the end of each month, we'll do, well, approximately for the year, we'll do about 1,500 administrative hearings, not in person, for reduction of minimum suspensions and yada, yada, yada. So there's enough work to go around.
And Fred, do you know like the specific process for a person to request a reduction in their minimum? Like, could you walk people through that?
So for reduction of minimum, they'll need to spend at least, I believe it's 1/3 of their previously set minimum on their sentence, whether it's open 5, 10, or 20 or extended. And then they can make that application. Depending on the facility that they're at, the unit will make a recommendation based on the institutional performance. The branch, which could be the warden, would make their recommendation. And then the division head would make his or her recommendation. So there's, institution has 3 ways to input on the reduction of minimum. And the board will review it at the end of each month on a non in-person type hearing, administrative hearing, and either grant or deny. And at times it may reduce it by 6 months, 3 months, 1 year, 5 years. The most we've seen is 10 years for certain lifers, yeah.
But that's a paper-driven process.
It's a paper-driven process. Exactly.
And it's sometimes it's to move the individual in terms
Not-
of classification or.
Not necessarily
social
for that express purpose, but if the person is, and this is the kind of beauty about it. If the person is performing and showing signs that they're rehabilitating, they're being pro-social, they're not involved in gang and misconducts, we can reward them and it incentivize them to continue doing well. It's less of a management problem for case managers, correctional officers, and facilities itself, by giving them some kind of hope and incentive. So that process is important, at least to let people know, or individuals know, that, yeah, continued good work will reap rewards. And people have benefited by that, so that they either reduce their classification, made themselves eligible for work furlough, and transition back into the community.
Are you aware of?
I think one of the other things that's been really important in our work on restitution and is that offenders understand that accountability to their victims, that the board believes that it's a demonstration of rehabilitation if you've tried to the greatest extent possible to pay the victim for the harm that you caused. And so that philosophy in and of itself really drives, you know, sort of like good parenting, when people realize, hey, I need to be, there's a manifestation of being accountable, of being rehabilitated, that really drives that piece for us and for victims. So we really appreciate the board's work on that, but that's an integral part of their release decision.
And one thing that should be pointed out is, I don't know when it started, Fred would know, but now everybody in the Paroling Authority has a history in the criminal justice system. Before that, it was, I don't know, friend of the governor or a used car dealer. I mean, it really was. And now the people on HPA.
Oh, you board members. Yeah, we've had all kinds as exemplified by the Supreme Court decisions on some cases back in the day. So.
Are you still enjoying appearing in front? I just want to speak as to restitution. One of the things with respect to restitution, whenever I send somebody to prison, I set the restitution amount pursuant to 706, 646, but the payment of restitution while somebody is incarcerated is completely controlled by chapter 353. So the rate of payment is taken out of my hands at that point and given squarely to public safety.
But the rate of payment is, like you say, statutorily required.
That's right, yeah.
But the reality is that the accounts that offenders have that show significant money, that the paroling authority has access to that information. So when somebody has thousands and thousands of dollars in their account, and they're looking to come out, the board is aware that they actually have the ability to pay more. And so it's not, it is not limited to in that way.
So restitution is collected when any individual who owes restitution, and we have the court document, and it's stated on our court action, that this is the dollar amount they have to pay. Case managers are well aware of it. So each report that we receive from the facilities and our pre-parole generally notates how much they have in their restricted, how much they have in the savings, how much they paid, or if they paid in full, CDCC and or court ordered restitution.
And do you guys have the authority to sweep those accounts if it's for the purpose of restitution?
No, we don't. And they voluntarily do so because they want to get
Parole.
and or possibly early discharge if they paid off the restitution.
And for us, it's really surprising, like when we took over collecting restitution for inmates and parolees, we thought that people would show up to our doorstep angry because we run a victim program, and then we were really concerned about that. But instead, what happens is that offenders who pay off their debt, what we see as people coming to our doorstep, when you pay off your car loan, you pay off your mortgage, that people who accomplish something that come our way and basically have a sense of accomplishment and personal rehabilitation in the fact that they've made good to the person that they hurt. So there's a lot of very interesting, surprising stories when we began this project about rehabilitation. We're always wishing that there was a way to study the impact of the payment of restitution and recidivism and this kind of stuff. We talked once to CSG, but it's kind of a mess, in terms of being able to collect data on it. But anyway, so
That's interesting.
it's been a very interesting experience doing the restitution and working with vendors.
All along the whole process, PSP is highly involved in collection of restitution. And the biggest amounts that are turned in are usually when they're in work parole and when they get on parole. So, and if they want to qualify, like I said, for early discharge and cutting the tail off their sentence, they've done spectacular and they have no more restitution or debt. That makes them eligible, but as long as they have restitution, they can't get their early discharge.
And our data shows that most restitution payments, the average case, people owe about $1,000. And so that for the most part, that people can make good or largely make good on their restitution payments as they go through the system.
So it's not too much additional work on the part of case managers and PSD or correctional officers.
I do think it's important to note though, like when talking about restitution, that the majority of that money, not that I'm against restitution, please do not take this way, but the majority of that money comes from the families of those incarcerated, because it's hard for people incarcerated to get jobs. If they do get jobs, they're maybe being paid like 25 cents, 50 cents an hour, if that. And so even though $1,000 may not sound like a lot, in the scheme of things, when you're not making a lot of money and you're working day in, day out, like that is really challenging. And so it does oftentimes fall on the families of those who are incarcerated. And so like, I think that's an important piece
It's very
too.
rare that families would put up restitution.
No, not directly for restitution, but it's families who are consistently putting money in those people's accounts, like for phone calls or for whatever situation, for commissary. So like, I'm not saying families call in and say, let me pay this restitution, but like the money that's put in. I just want to make the point that like, a lot of the burden can go on people who weren't a part of committing the crime, you know what I mean? So I just,
Well, I think when people get money, like, you know, if I gave Steve money, and he owed a debt, it's his money.
yeah, I
You know,
don't
the
disagree, yeah.
statute requires
Yeah.
more than 25% of the money be taken, so
Right.
we were very mindful when justice reinvestment, that's when the restitution provisions came into being, that you're leaving somebody with 75%, but you're making good to the victim. And, you know, you can go down the hallway in the courtroom to the civil courtroom, and nobody cares who gave you the money and how you got it. You're held accountable. And in this case, you're found guilty beyond a reasonable doubt. And it's your money. So I understand what you're saying,
Yeah.
but I think,
I just think the context of where the money's coming from is important. That's, I'm not saying that
Yeah.
they shouldn't pay, that shouldn't happen. Like, I'm just.
well, because like
yeah.
you said, it ends up their money. So
Right.
they have the ability to spend it. So why would they not? Why would they be able to buy chicken with stuff they can buy and TVs and stuff on the mainland, at the mainland branch, and not make it to their district?
So is there a process in place now in those who are working in the system? And have restitution that they're getting pulled the 25%?
So the statute says that an inmate account, that any money that comes into an inmate account, 25% of that is garnished off the top for restitution. So like I said, when that was created during justice reinvestment as a justice reinvestment provision, there was a suggestion that it be more. And the victim community was like, no, we want offenders to be able to keep enough of their money to be able to be rehabilitated. We felt like if it was more than 25%, it was get the balance about needing an offender to save money and being able to buy stuff. But think of it this way too. If you don't get any money, you don't have to pay it. So there's no problem in about ability to pay or punishing an offender who's poor. It's only if you actually get money. And so what we saw during the pandemic too, restitution shot up from inmates because tons of people dumped money into inmate accounts, family members, during the pandemic. So we saw a huge increase in restitution collections, counterintuitively during the pandemic. And also people got money for getting COVID shots. So there's a lot of money going into accounts. So I mean, like the flip side too is if somebody's got $10,000 in their account, no matter where it came from, is it really okay if they owe a victim restitution? They get to spend the $10,000. I get what you're saying, but that's the flip side of it.
Why do you think more money came in during the pandemic?
More money came in because people looked at people they knew in the facility, and I think felt a greater generosity and concern about it's harder in the facility, want more people to have more money to buy more stuff. So people just dumped huge amounts. Like I said, the restitution, all our data shows it skyrocketed in facilities that were collecting.
Plus, there was money coming from the government too, right?
Yeah.
Even for
tons of
inmates,
people.
everybody was getting a check.
Yeah, and some of those precluded payment of restitution from those government checks from during COVID, that the later ones precluded us as being spent for restitution. So query whether people felt like that was fair, that they got straight on checks for payment and never got to pay restitution, but.
So a lot of them saved their money,
Yeah.
the COVID money, but the spending increased because the savings increased because they didn't spend as much because there wasn't as much in canteen. And then,
They should know.
you know, there weren't as many jobs because a lot of people are locked down.
Mhm.
So that's the other thing. But as long as the individual is making an effort, whether it's 25 cents or $1 towards restitution, it's acknowledged. And it's seen in all the reports as well, to the board.
Yeah, and even the statute says, like, for, in the case of probation, that, it's mandatory that restitution is ordered. That the court shall not consider the defendant's ability to pay an ordinary restitution, except as it relates to a payment plan. So the court, even on probation, makes a finding that the offender can afford to pay this much. So even on probation, the court is only ordering what the defendant can afford to pay by definition in the statute.
Well, we can move forward.
Okay, I wasn't sure if there's anyone in the room who's with the Office of Hawaiian Affairs, but this is a very terse summary of the statutory mission for the office, which is this is new for me. We don't have an office for Texan affairs, I don't think. But it's a really sprawling, interesting mission that they have that's not only about Native Hawaiians, but conditions for all Hawaiians. So I thought this was interesting for me just to explore what's on the books about this office. And I think there's a set of questions that has to,
Native Hawaiians are the only Hawaiians.
Yeah.
Right, yes.
Yeah,
you said We don't call it, we're not like Californians. It's,
is that
just
right?
because-
Yeah.
it's Hawaii residents, not
right.
Hawaiians.
If you
you're
say
not native
Hawaiian, you
Hawaiians.
gotta have Hawaiian blood.
Yeah.
Okay,
Right.
thank you. That's good, info.
Blood quantum of Native Hawaiian, that's the distinction there that they're making in terms of Native Hawaiians and Hawaiians. It's all Native, like Steve just said.
Except in prison stats, PSD stats, it's all self-reported.
Yeah.
And this is a lot of them called hard native Hawaiians in that, yeah.
So we know there's some pretty stark disproportionality in your system or disparity around the presence of Native Hawaiians in the criminal justice system. And Mark, I think you and I have talked about this a little bit. Any observations or context to provide the group here?
I think really what we want to know right now, I mean, in your individual capacities and organizations that you represent or agencies, are Native Hawaiian numbers collected in terms of what comes through?
I mean, do we track that as
Yes,
a variable?
track that as a.
We do.
And is that a self-reporting element?
Ultimately, I think where it comes from, it is because it's typically reported on at arrest, right?
Yep. Or at the PSI when they're talking to the PO, which is, I think it was 42% or something like that. Self-reported.
Yeah, reach out to our courthouse as well.
Yeah.
Sieges.
Yeah, see this.
But that could be 50%, 5%, it's whatever the person wants to report.
Or do you folks collect data on how many come in front of you, how many are paroled?
On parole, by ethnicity.
No. Okay. Oh, we'll definitely come back to this as we talk in between meetings to try and develop a more robust way to talk about this by the data that's already been collected. Yeah, there is definitely when we look at disproportional treatment across the nation. Yeah, whether it be African Americans, Latinx, et cetera, et cetera, et cetera. We know that through the system, there are always key points where certain ethnic groups move through faster than others. Yeah, and in our process that we talk about, we want to see if we can identify if that's what's happening here as well. Are gates closed to them? Are gates open to them? Why are we seeing more and more as we go further through the system? Yeah, so we'll leave it with that at this point, Carl.
Okay, now we're just, I wanted to remind the group of the statutory duties outside of this task force, which is created by the resolution. The existing statutory duties of the Correctional System Oversight Commission, really a pretty sprawling mission. And I think this is a relatively recent phenomenon that this group has both created and given this broader mission. One thing that struck me looking at this is that it appears to reflect only oversight over what's happening in the executive branch. That's not explicit, but I wanted to kind of bounce that off you all. It doesn't strike me that this includes the things that happen in the criminal justice system outside the executive branch. And I just wonder if that rings true to you all. And for example, the judicial branch.
Yeah, we have absolutely no jurisdiction over in looking into or investigating anything in the judicial branch. I will say, the judicial branch is very kind and open to us. Like if we have questions or if we want to understand processes better, I've never had an issue or concern from the judiciary. When we bring up the concerns, and this is specifically in relation to the jails, but when we bring up concerns of overcrowding, we do make it clear that that is on the judiciary. The Department of Public Safety cannot say, no, sorry, we're full when they're full. And so it is frustrating for the commission to see, for example, very low bail amounts. I've seen bail amounts at $5, which blows my mind. But, you know, again, the judiciary has been very open to us, sharing our thoughts on that with them. And, you know, one thing that we really want to do is just do more education of how, you know, when you set particularly such low bail amounts like that, you know, to me, if you're setting a low bail amount like that, like it's not necessarily saying that this person is a danger to society, because it would be relatively easy for that person to pay the money if they had it, right? And so this becomes really relevant with our second piece there. Like we set the population limits for the facilities. Those population limits are pretty specific to federal standards and federal guidelines, like right down to the square footage of what's required for ACA standards. And so, you know, there's no like getting around it of like, oh, you can use this massive room and just throw more people in there. Like we can't do that, right? And so we also have to set policies and procedures to prevent the inmate population limits from going over, which is a really interesting thing to put on the commission, but we're here for it. We're here for the challenge. But that's where, you know, we can kind of educate the judiciary more and just like talk to them more about, you know, how some of the decision-making can really affect the inmate population. And we can be a little more like open and bold than I think the Department of Public Safety can. Like they're kind of in a really tough spot, where it's their job to take these people in. So we try to work with the Department of Public Safety and just telling them, hey, if there's things that you don't want to say openly, throw it on us, you know, we can do it. But yeah, but other than that, like we have no jurisdiction over telling them what to do, or, I mean, even if we requested information, like they don't have to give us anything.
Thanks, Kristen. That's very helpful.
Can I just say for clarification, you're almost never gonna see somebody with a $5 or $10 bail when that's their only case. You know? In those situations, people are gonna be ROR. Where you see $5 and $10 bail set is when somebody is out on SR or out on bond on one case and they pick up another case that they can't make bail on. If they sit on that second case, but they're still on release status on the first case, they're not getting any time credit on the first case. So one of the things we do is we set what they call nominal bail on the second case, $5, $10, so that at least they're getting time credit on that first case. So that when it comes to sentencing, because they're gonna be in anyway, they've accrued all the time credit that they're entitled to. So, but in terms of a standalone case, somebody having $5 or $10, I've never, and I've been doing this, Steve.
Yeah.
No, absolutely.
I've never seen that.
Not to toss the Third Circuit out there, but Kelvin and I have gone back and forth. We've seen it in the Third Circuit.
We're talking first.
Yeah, I understand you guys are talking First Circuit,
Yeah,
but I'm just saying like
okay.
statewide, it does happen. I've seen it. And so, you know, that's just something that, again, the commission's concerned about, especially when HCCC is the most overcrowded, you know, it's also one of the smallest, to be fair, but it is one of the most overcrowded facilities in the state.
Understood.
Well, and you have a judge there who's actually said, don't send people to jail because of the overcrowding. And I don't think that's ever happened here. I don't think judges consider how crowded the institution. If the person needs for public safety to go to prison, they should go to prison. And in most cases not, but I've never heard of a judge considering that.
I think it would be illegal. You know, my considerations for sentencing are enumerated in 706-606. It does not say in 706-606 that I should consider the population of any particular facility in sentencing someone. That should not enter into my analysis at all.
But that'll never make it on the record, right? I mean,
Yeah.
that's the probation versus prison dilemma for the judge too. They may not say it on the record, but
Well, it's almost always gonna be probation, anyway.
Can I say something real quick? Can you guys, when we have a hearing, can you guys bring that up? Because the narrative is different too. So it's good that.
What they
people in
think
the-
people are not sending people in there.
But, like you just said, right, there's, rarely does it happen on the wall. So the perception.
The other thing that's not being mentioned is if you look at chapter 706, there is a release valve statute, which allows the director of the Department of Public Safety to release people early due to prison overcrowding.
Right,
That is codified in statute. And particularly for folks that are being sentenced misdemeanors, things like that, if OCCC gets too crowded,
mhm,
the director of public safety does have the current ongoing authority to do sort of a release valve and release some people early. I don't know whether that's ever exercised or not, but that was one of the things that we were, as judges, were concerned with when the COVID orders came down, requiring us to release certain classifications of inmates. Our feeling was, and with all due respect to the public defender's office, our feeling was that authority is already in place through existing statute. So exercise your authority. It's not my job to tell somebody who's not on, to tell the Department of Public Safety to release somebody that's not on bail status, meaning who's not pending a trial or pending a revocation. I have no authority. Once that person is sentenced, they belong to the Department of Public Safety. And the Department of Public Safety can use their own legal authority to determine whether they should release somebody early or not based on overcrowding situations.
and that's for sentenced people, right? Like, not for pretrial, or is it both?
So for pretrial people or people who are in on revocations of probation, they're subject to bail. So the judge would have to say, either I'm gonna set aside bail, or, so that's why I say, I have authority over those folks.
Right,
But everybody who's sentenced,
right, but it's the pretrial population that's the issue here, as far as like overcrowding.
not necessarily, because OCCC includes not only pretrial population, but also sentenced misdemeanors as well. That's the population that I'm talking about.
Right,
And the sentence felons with jail, probation with jail.
yeah, the probation ones are a big one too, yeah,
Yeah,
yeah.
yeah, the
Um,
sentence, the probation, where jail is a condition of probation. That's absolutely right.
And so during COVID, a lot of things were exercised and the committee, proposed on the AGs, prosecutors, judiciary, Dan Foley served as the master and the coordinator for that. It was all examined and it was looked at, and within everybody's purview, they could do whatever they could do. So as far as relaxing the criteria for release, parole did that. Parole, PSD, they did what they could. And then sometimes you have to work conjointly, especially for medical type releases or reducing the age of those who require medical treatment outside of the facility. But instead of 65 as a court order, we dropped it to 55. So a lot of things were in place, a lot of people were doing things without having to get a court order. But it was the situation at the time.
Yeah, and again, like, it's not to throw out any different departments. I mean, I think the commission's viewpoint is like, especially because we look at system-wide, like, we see all the issues on a system-wide level, right? So it's hard for me when I hear people saying, well, that's not my job, or like, this is my specific route, because it's like, I get it. But also it's impacting the entire criminal justice system. And I think that's one of the massive benefits of groups like this, because I mean, can hear everybody's different perspective. I really wish Tommy was here. But I don't know. Anyway, Keldon, I'm sorry, you've had your. hand up for a while.
Keldon, you wanna comment? We mentioned you guys.
I'll keep it brief, but Judge mentioned earlier about nominal bail. So it's the same principle here on the Third Circuit. Kristen and I have talked about this a lot, and I mean, we've tried to coordinate where I've been very open with partner agencies on Hawaii Island about situations like that. If they know of if an inmate being in custody on $5 bail, 10, whatever it is, I told them to reach out to our office. I've given people my cell phone and I've given them my email, and we've tried to talk to the defense counsel and work to see how we can resolve cases or whatnot. But a lot of times it's situations with nominal bail. So one of the difficulties we have on our island is that we have a number of different courts. As for those of you who practice on our island, there's circuit courts on the east side of the island and the west side of the island, and there's district courts on both sides of the island as well. So there may be an individual who has criminal matters in Kona Circuit Court in front of two different divisions, in Hilo Circuit Court, in Puna District Court, Hilo District Court, South Kohala, North Kohala District Court, and they could have a number of cases all across the island. And we try our best to do global resolutions of cases. But if one case happens to fall through the cracks and the individual was set $10 bail on like a criminal contempt in one case where the diligent public defender who was representing him at that time asked to set nominal bail so that he would get credit for time served while he was being held on the other more serious felony matters, there have been situations where individuals have been stuck in custody after the more serious matters were resolved, where he was pled, sentenced, and maybe even subject to release on the more serious cases and still remain in custody on the lower bail amounts. As I mentioned earlier, you know, the overcrowding situation at HCCC is a very well-known challenge that we're dealing with. So we try to be proactive and try to free up space for an individual who's, if they're only being held on $10 bail on a contempt. There's been situations where we've had people held on petties past 30 days and our office filed motions to dismiss the charges, you know, on like a non-victim case, on like a contempt or something like that. So, I mean, we're trying to do what we can with limited resources here. I really, you know, not to throw other departments underneath the bus or anything like that, but I think it's about advocating for funding and resources. I think if public safety had the ability to have a more updated and enhanced form of intake and tracking the incarcerated individuals, I think that would be very beneficial to them. And we might even alleviate a lot of these types of situations. The offender tracking services that are available to them is very outdated. A lot of it is manual tracking. I know this because my dad worked at HCCC for over 30-something years. He was the trans sergeant for a long time, and he used to manually check basically what they call a roster and a court calendar, and that's how they determine who gets sent to court. Now, on an island like ours, where we're a big island, small community, you have fathers and sons, other family members all incarcerated together. Sometimes they send the wrong inmate to the wrong courthouse because of the name familiarities, and they're not double checking SID numbers, SSNs, and DOBs. So a more robust form of an intake system to track offenders would be very helpful. When you look at it, we're all, you know, all the state agencies, it's interesting to see how not integrated public safety and the judiciary are. We have this JEF system that is utilized by all the counties, all the state agencies, but it's not integrated into public safety that would make things automated and easier for public safety to track offenders. If we can do something with that, I think we would alleviate a lot of these types of situations where we have people being held on nominal bail amounts.
And the good news, Kelvin, is that PSD is actually updating their system right now. They're working on that. Yeah, they are going to update their offender track system because I agree. So at least that's some good news.
So this last couple of questions are directed at Kristen, at you and Mark. Just kind of reflecting on how this topic that we've been discussing, and I think the last conversation really kind of answers this, but how does the HCR 23 issue, how does it inform the other work that you all are charged with under your statutory mission? And what have you absorbed? What is the community telling you all about this topic that we're discussing?
We don't have enough time left.
So I can share some of what the community has shared, but first of all, I want to make it clear that this is just what people are sharing with us, number one. And also, you know, the first part of the question says, what observations? So I'm going to take those like HCSOC observations. I will say that Fred has been really fantastic since I first started in helping me understand the system, but especially when we started looking into parole, he was the first person to say, come sit and watch parole hearings and tell us what you think. And he was totally open to you know, what our thoughts and what our opinions were. I will be honest that we do receive a lot of complaints about parole, but it's pretty specific to one member. I don't think it's the board as a whole, which is good and bad, I guess. But overall, what we hear is that people are really unsure of the fairness, especially when setting the minimums. There's this mindset that, you know, when the parole board isn't in the courtroom and hearing the entire case and being a part of it from kind of day one, they're just not in the best place to set the minimum and make that decision. We've heard a lot about how HPA can be really, really strict and also unknowledgeable about like criminal justice, but I know that Fred's fixed that. So these are like more long-termers that we're hearing from. People who were given their minimum a long time ago. I took some notes. People feel like there's a lack of accountability because they can't sit in on the hearings, or they can't like request a video or recording of the hearing afterwards. So we hear that a lot from family members, I think in particular. There's also a lack of understanding of what people are pleading to. So they might think that when they're pleading in court, like they might think that they're pleading to a minimum of 5. And then when they have their minimum hearing, they might get more. And so there's a lot of concern with that. And that also flows into, I think, the point made earlier about a lack of predictability too. Those were the notes that I kind of jotted down. Did you have more to add, Mark? No, so yeah, so I think overall that's what we hear a lot. Like there's a lot of unknown. And so what we hear a lot is that people want like more consistent reporting out instead of just the annual reports, like just more information in general. So yeah, the commission tries to help with that. Just by, again, like going to the parole hearings, reporting out about how it went. And, you know, you can look back at our reports. We really had nothing but good things to say. We thought the parole board was very, very thorough. You know, we didn't see as many setting of minimums as the other cases, but, you know, still, I think it's important to note. Yeah.
What percent of your input or feedback are you getting from the victims?
We have heard complaints from victims, but not as many victims reach out to our office in general. I think probably because of our reporting, right? Like we're reporting on conditions of confinement, we're reporting on, you know, trying to help people have better living conditions in particular. So I think the victims think that they're probably not a part of that, which is not true. Like we want to hear from victims as well, but you know, I talked to Pam about this a little bit, but like we need to do a better job of highlighting that. Like victims can also call and talk to us. We did hear from victims when this task force came about. I got a few different calls, and mostly it was like, why is this changing now? Like why, you know, like why now? Like there was just not understanding. But other than that, as far as like the parole board specifically, I mean, we really don't hear from victims, I think, on that topic specifically. The vast majority of our complaints from parole board specifically come from longer term guys. So most like the overwhelming amount of complaints that we receive from Saguaro is about the parole board. So I don't know, take that as you will, but
Glad it's not about the judge.
well, they know that we can't do anything with
Can I
that.
add on to that?
Yeah.
So I know everybody receives all kind of complaints and comments about parole board, but they also write to the parole authority. And we receive hundreds of letters. And Corey and his staff respond to each and every one, as repetitive as it is. And the normal time frame is within 10 days of receipt. I review each one, initial off dated, give it to Corey, he or his staff will respond to each and every letter. And in the inmate file, you will see stacks of responses Some of it's the same thing,
Mhm,
you know, same thing they may be talking to you about, but,
mhm.
you know, it is the policy of me to respond to each and every complaint, inquiry, Rule 40 inquiry and everything else, so, you know,
Yeah,
it is what it is.
yeah, and Fred, like, also always has an open door, like, if I get complaints or get concerns, and I give him a call, and I'm like, what is happening here? You know, he's always very helpful and responsive, and in fact, there's actually a victim, when this task force came up, a victim called, and they're upset over a case that happened a long time ago, but they're saying, the individual received a reduction of minimum and they weren't notified of that process. And so they're really upset about the notification process, and they weren't trying to like relitigate the case, but they wanted to help make the policies better, for moving forward. And so, like, you know, I connected them with Fred. Fred was more than willing to sit down and chat with them. And so, you know, the commission, like, there's always this mentality of like us versus them, right? But I will say, like, the commission tries very, very, very hard to address things directly with the Department of Public Safety or with the parole board as things come up. And we, you know, really try to show, you know, from our perspective, from an outsider looking in, of like what is happening as a whole. And so that's why, like, when we talk about overcrowding, we try to make it very clear, like, this is not the Department of Public Safety. Although I hear you that they have some leeway in letting people out, but anyway, I got a little off topic there, but that's mostly what we hear.
But most of the complaints that are focused on a board member, that board member is gone, right? Or shortly soon to be gone.
They're supposed to be shortly soon to be
They're
gone.
paneling, they're developing the interview panel. They have a list of applicants, and hopefully soon they'll be interviewed.
Yeah.
But I get to make my spiel before the interviewing panel, before to give them the job expectations, the great. But what we look for, the qualities that we look for in a parole board, that will be objective and fair and all that good stuff.
Carl, we have a few minutes left in our time frame. Do you wanna talk about it, bring this to a closure before I go into the next meetings?
Sure, I'm pretty much done. I just pulled up what I think is our last slide, but just to kind of segue into what you want to talk about, Mark, the process from here. What questions do people have for us that we could delve into, that sort of thing?
Yeah.
If it's helpful, I can tee you up on that, Mark, if you wish.
Well,
Okay.
we had a couple of questions for the board members as I'm looking at this slide, Jen. So as the slide indicates, like, August 1st is when proposed legislation is due, and October 1st is when the final report, including like the findings, the recommendations, the legislation is due. And so if we continue on a quarterly basis from November, then that would put us in February, May, and August. If we kind of shift the schedule a little bit and meet again in January, then we could do January, March, June, and September. If we keep the quarterly date. So I just wanted to check in with people to see kind of what everyone was thinking, like if it would be okay if we shift to January, just so we can squeeze that extra meeting in before legislation is due, or if people prefer February, May, August.
I would prefer January, because come February, March, April,
I
man,
know, legislative, yeah.
as everybody knows.
And even if we do the January start date, you know, September will only happen if we need to.
Yeah.
Okay.
So if it's okay with everyone, if you don't mind pulling out your calendars, and I promise I won't mess it up this time. Sorry for last time. But I just wanted to run through the dates just so we can set it now for the future, and I can put it all on the website so we can have reminders and everything. We can send out calendar notifications. But I was looking at to start Thursday, January 4th. No. January 11th. Maybe January 11th. Would that work?
What day is that now?
January 11th is a Thursday. I was trying to keep it to Thursday because I know the judges get slammed.
That's usually gonna be our Maui hearing.
Or we can do Fridays if Friday works better.
Oh, yeah, Friday. The Thursday would be better.
Thursday's better. So would January 11th work for people for January?
That's good. I'll set
Okay.
that down for January 11th.
So January 11th. And then I noted March. Sorry, March.
Oh, March, okay, go ahead.
March 7th,
I'll be out of state.
March 14th,
Better.
March 14th. All right,
I'll be gone.
you'll be gone. We can't do the 21st because that's the commission meeting. We could do March 28th. Does that work for everybody?
I'll be on.
You're looking at Thursdays?
I was trying to focus on Thursdays, yeah.
Who's that,
Yeah.
So,
Or we could do,
did we ask the 7th and you said you weren't there?
I thought we said the 14th.
March 7th, I did. Okay,
yeah, March 7th, we have parole, March 14th. We have Pam, March 21st, we have the commission. We could try Friday, like March 8th, Friday?
March 8th. I'll be gone.
Oh, that's right, you're gone. I'm sorry, Fred. March 15th, which is also Friday.
Yeah.
March 15th. All right, locking it in, March 15th. Thank you, guys. And then skipping to June. March, April, May, yeah, June. I put down June 6th. Which is again a Thursday. June 6th. All right, June 6th. And then September, which will be our last meeting, which is exciting. I have September 5th, which is a Thursday. September 5th?
I'll come as a guest.
Good.
Well, my term ends June.
Kristen, there might be a short week because of the holiday, Labor Day.
Shoot, thank you. Let's avoid Labor Day. So how
Let's not
about,
work on Labor Day.
how about September 12th? Another Thursday, September 12th? Okay,
Would you be able to email us all these dates?
yeah, absolutely. I'm gonna send calendar invites too, yeah. September 12th. Okay, so we have January 11th, March 15th, June 6th, and September 12th. And then, August 1st for proposed legislation, October 1st for the final report. Thank you all.
All 9 AM.
Yeah, does 9 AM to noon work for everybody, it seems? Okay, great, yeah, 9 AM to noon. And hopefully we can drag Carl and Jen to come join the fun in person.
Cold in January.
Yeah. So that really brings us to kind of what the task force members what would be most beneficial for those meetings. And so I think kind of working backwards, if we look at the June meeting, that's probably going to be really focused on, are there any legislative recommendations, right? So you would need to have a lot of the information already ready from the January and March meetings. And so kind of sequencing wise, I think in terms of data that the task force would want to see, that would probably be coming at the March and June meetings with the data. January feels really quick to be able to kind of analyze and put together all of the data stuff. And there are some, activities that we can assist the task force with and kind of engage in these types of activities to be able to bring additional information to the task force members, if that would be helpful. Some of our typical activities would be reviewing policy and procedures, how things work, whether it be PSI content, assessment policies, minimum setting or minimum reduction policies, conducting observations and kind of highlighting kind of findings and recommendations for the task force members, conducting focus groups with people who are incarcerated and most impacted by these policies, and engaging with stakeholders, especially ones that aren't represented on the task force, such as, impact on staff and workload associations, people with lived experience in the Hawaii system, as well as advocates. And so wanted to know if there's kind of certain things that are top of mind for task force members that you want to really see and understand in order to start making recommendations.
I mean, we can squeeze.
Yeah, I think what I'm gonna suggest at this time, Jennifer,
I'd like a chart that compares the quality and type of information that Fred has access to make a decision on the minimum versus the quality and type of information that the judiciary has similarly situated, to see what those two things are.
so on the handouts that you received today of the PowerPoint page, the last two pages, 40 and 41 are the questions that HCR is bringing forth in order. After two meetings and discussions, what's on the front of your mind right now? What needs to be answered from your perspective? What else can we bring forth in our next several meetings to discuss to help us in the mandate of HCR 23? We know that we are having discussions right now, the commission with SCG, really looking at what's out there in terms of data that can help us describe the sentencing process in our system. And, you know, we recognize for those of, well, all of us are state workers and whatnot, that we all have our own challenges with collecting data. And processes are antiquated and we don't do a good job as a state in terms of staying in tune with technology. So we're gonna be looking at what's available, what's not available, and how do we get to a point where we can get the best information to help us in our decision-making around this table. So any kind of data collection, if we can figure that out before Thanksgiving, Aaron, you know, we wanna have a time period, so we won't see anything till maybe April. Yeah.
So one of the data points I would be interested in is knowing how many offenders are staying beyond their minimum term that's set for the paroling authority and what the reasons are. Because when I sat on the board, you know, we know that the lack of programs was one impediment for getting people released, but it would be helpful. I think that's one of your guys' jobs,
Yes.
is to find out, you know, how we can get people released. And that was a big problem, is not having enough resources out there that we can release offenders to.
Okay.
So I think that would be helpful to get numbers.
We want to be able to, you can email us your responses or your, as you ponder this over the next month or two. But yes, we'll look into that as well. And we'll probably be sharing with you what discussions we're having as well, so you can be a part of input.
Yeah, I just want to have adequate time after we see all the data. The data tells one story, and there's other things in between the data that I think should help clarify certain things.
I mean, we could, just by what we were talking about today, you could see all the questions pop up. That little data piece that we had, so I agree. Rick Elsham, any final words?
Oh, for the January 11th meeting, you know, the hearing room that we have for public safety? It's about half this size, or, this room will be reserved for another committee. So if we're gonna meet at the Capitol, I can do it in the public safety, my committee room. But it's, you've all been there, it's kind of small. And we can't sit around the big table like this. If that's okay, if not, we would have to find another office.
So we could go back to the first meeting space at the DLNR, right? DLIR building, or we can stay at the Capitol, but just have like not a table. Well, people.
Perhaps we'll set reservations for now, and if something else presents itself, we may bring it in.
Okay.
Because we have, what, 2 months away?
Yeah.
I just didn't know if people prefer having the writing space, like having the table, or if that's.
The table's pretty good, yeah.
You want a table?
Is it possible at the last minute to see what is not being used?
We could.
I mean, reserve yours, but if not, isn't there gonna be one that's not, or no way to tell?
No way to tell now. as of now, because they might have informational briefings or whatnot. The committee controls that room at that time. So it's up to the committee chair to release it or use it or however you would. So the room that we have for public safety is, I will control that room as of January.
It doesn't have a table.
It does.
Or not a big one.
Not a big one like this.
At the state office tower?
Second floor.
Can we rent that? Can we, put-
we did last night, so.
at the state office tower?
Yeah.
Huh? Okay.
Availability.
So we can just set the date and figure out the room
Yeah,
later.
there's enough time. to do.
Yeah, the other location that Fred just brought up is at the state office tower, which is just a block down, so that might.
They have the
work too.
technology.
We'll make it work.
Okay.
And this
All right.
is really convenient with one big table. so.
I want to thank everybody for your presence here. My apologies for the 10 minutes over. But that was some great discussion and appreciate your presence here. And if I don't see you again, have a happy new year. Christmas, Thanksgiving, and aloha, and we'll see you next time.
Thank you.
Mahalo.
Yeah.